passed by the Honorable Supreme Court on 3rd April 2025 in civil appeal number such and such. She approached the court for extending the validity period for joining in terms of the recommendation letter issued by the commission. Stop paragraph. Several such matters were dealt by the court, and upon hearing submission made on behalf of the petitioners and the commission, the court passed order on 9th December 2025 in WPA 22882 of 2025, Shankar Prasad Haldar versus the State of West Bengal and others, which is relied upon by the petitioner. Step. Acha. As the facts in the instant case are similar to the one of Shankar Prasad Haldar within brackets Supra, similar direction is being passed herein. Stop. The commission is directed to recommend the petitioner, subject to availability of matching vacancies, only after 1242 vacancies, process of filling up the same is continuing, is filled up. Stop. Next. The aforesaid direction is being passed, keeping in mind the order passed by the Honorable Division Bench of this court on 25th November 2025 in MAT 1512. Eta copy korben to. Paragraph 4. ঠিক আছে? এই যে keeping in mind order এতে এত ম্যাট এত ঠিক আছে এতটা the writ petition stands disposed of. Service is taken on record.
There is service to give.
আচ্ছা impugned Subroto Babu, impugned order of rejection stands set aside. The impugned order of rejection stands set aside.
Nah, similar detector slide. Well, issue is similar, but this is the first round of litigation.
All right.
Extension of recommendation.
Please
this is
come.
First round of
I know
litigation.
this one I am objecting to this particular matter.
All
because
right.
They have approached the court after expiry of the panel.
Yes.
No.
They sat tight for 1 year after the recommendation. Now they are approaching the court after 1 year.
But by
Panel expired, maybe job loser, but you sat tight for 1 year. The panel expired on 25th September 2025.
In the matter of Shankar Prasad Haldar, it is the same thing.
No, but they had approached within the lifetime of the panel. The reasoned order was passed and in the meantime, the panel expired.
That was in the last matter.
Yes.
But the earlier matter in which, relying on which this order has been
No,
passed.
that was also against a reasoned order.
My lord,
All those matters were
my
against.
lord, subject to correction, this point was taken by the commission before the honorable division bench that panel was expired. Since the honorable division,
They were time. They were all within time. My lord,
let me finish. Let me finish, doctor.
No, you are misinterpreting my argument before the court.
My lord, this
Definitely object.
I have taken, well, since job loser is a special circumstance, and honorable division bench hold, no. This is not a ground that panel expired, that they should not be facilitated. And my specific case, my lord, petitioner number 1, this petitioner appeared in the second SLST 910 and 1112. Both have been, they have failed to qualify. He has been failed to qualify. So this situation, my lord, Otherwise, my lord, petitioner will suffer irreparable. That is why, my lord, petitioner before your lordship, job loser is a
Thing is, you all take advantage of everything.
Yes.
The first SLST, the second SLST, the regional test, everywhere.
yes.
It is all right. If people looking for a job, they will.
No,
They
since my
will,
lord, they approached before
take
the
this
commission,
approach.
they approached before the commission within time, but they failed to approach before the court in the admittedly, my lord. Panel, but honorable
Where
division-
is the document to show that you approached the commission
yes,
within
yes,
time?
yes, yes. Lord, kindly see, my lord, page number.
17 is the recommendation.
So 17 is the recommendation. I approached it before the commission, my lord, on my lord, within in the month of April, 7th April, on page 90. Within 150 days, just after third April.
He has to approach within 90 days. The
Seventh-
recommendation letter was alive for 90 days.
90 days, but he may be extended for further period of 60 days for special circumstances.
Nobody has extended.
Yes.
You suo moto extend it.
No,
Then
yes. No, my lord, 90
And
days.
even if a representation is
17
made, it
দুজন বললেন।
no reply. Yes, because I also have a right to
আরে
write of
তুমি
audience.
বলো,
Let me
আচ্ছা, ঠিক আছে,
say
ঠিক আছে, তুমি
something.
বলো তারপর আমি বলবো, বলো।
7th of April 25.
The rule requires that I will only communicate if I extend. If I have not communicated, it means I have not extended.
Yes, my lord, এবার আমি বলি, my lord, 17 rule 17(3) specifically said, but a recommendation valid for 90 days. But special circumstances, commission may extend it for further period of 60 days, but not beyond 150 days.
So it has not been extended.
It has not been extended,
Then
but since, my lord,
it lapsed.
the lapse, my lord, similar facts and circumstances, my lord passed an order and honorable division bench, since relying the decision of the honorable division bench that job loser is categorically, job losing is a special circumstance. They should be, my lord, considered. And my lord, we have come in the zone of consideration 14,052 candidates in upper primary selection. There is no, my lord, ambiguity. So, my lord, similar order may be passed. My lord, panel September, I have approached within a very short time, my lord. This scenario is a special circumstance, job losing. So, my
Let learned friend show in which division judgment.
Yes, yes, division bench-
judgment. It has categorically been specified
No.
that they are special candidates and they will, whatever they pray for will be entertained. I have not come
Okay.
across this order. I've only heard of it.
judgment.
Show me the division bench.
Yes, yes.
But what
At one
they
point-
left their jobs for them, the Supreme
At
Court
one
made the
point-
special arrangements.
At one
Not for these candidates. They were also before the Supreme Court.
At 1512, it will be. Mat 1512. Short. করে বের করুন। My lord, just 1 minute.
তুলুন একটু। তুলুন আরেকটু তুলুন।
হ্যাঁ।
Yes. Yes, it only mentions about the participation in counseling subject to availability of matching vacancies, and all your submissions are recorded over here that he is an absentee candidate,
Yes,
do
yes.
not have a chance. So
These are not absentee candidates. They participated, they took their recommendation letters and then they sat tight indefinitely. They made their extension prayers after 90 days and they're filing their writ applications at least 5 months after expiry of the panel or 3 months after expiry of the panel. They've delayed so long. It only shows
Uh,
they were not interested at that point of time.
Tell me one thing. How many vacancies? 1242 or something?
Yes, 1242.
1242 vacancies.
That has actually become 1243, but still one. It is
All
to
right.
the.
But then, what is the stage? It's still continuing.
No, what has happened is that our vacancies got exhausted. We were facing contempt, and we have, in the contempt proceedings, we submitted before the court that we have no further batching vacancies. So the court directed the education department to give the batching vacancies only for 1242, only for that purpose. Now we will have probably a handful of vacancies still left, which might match with the vacancies.
Any of the.
So these orders which are now being passed, these candidates will go for those vacancies. So that is also by now quite a large number. So those who came within time, those who came within reasonable time, those your lordships are giving directions. We are keeping a list of their names. As soon as we get the 1242, the government has not yet given it. The contempt will be fixed on the 15th, because on that day the learned advocate general will address the court. On the 15th, probably some directions will be given, after which the 1242 will be getting their recommendation letters if we get the vacancies. Then if we have, say, 100 or 50 or 25 leftover vacancies which match with the candidates, then those vacancies will be given to them.
Right.
That apart, we have a large number of vacancies, but they will
But
not
that is
match.
a separate process.
Yes.
That will be a separate
Yes.
process. It's not that.
Yes.
Whatever is available, in case it is
Yes.
available, then
Yes,
you can
yes,
consider
yes.
it.
No
It's
problem.
nothing.
Yes.
doing.
Nothing.
But unnecessarily increasing the number would put a burden both on the commission and those candidates who are.
Why on the commission? Because your vacancy list is filled. Is a finite number, not an infinite number.
Yes.
You know, it's quantified that you have got 20, 50, 70, whatever. If the petition doesn't match, it goes.
Wait,
It's
That's
as simple
correct.
as
But,
this.
but at the same time, if I indefinitely
is
go
not
on
that-
adding, there is also a possibility of missing a candidate. It's not like that all left out candidates will be given the option. Only those
cannot
who
be
have
matching.
orders of court,
Yes.
only those few candidates I am to call. So if the list constantly changes, if it is the list is candidates
Addition.
are adding,
Yes.
it is difficult for us to keep track of it. That is, it might give rise to mistakes every time the list is changing.
Somebody
Because I have
you have a pool, somebody will be added. Where is the mistake?
But the possibility is
trying-
always there.
No, I'm just trying to figure out. There is a pool, right?
Yes.
One more entrant to that pool.
But it is not stopping at one, it is going on and on. Today, my learned friend has
Assuming-
3 more.
Assume
Tomorrow, he will come with another 5.
maybe, but then your vacancy is fixed.
Yes.
The moment it is filled up, the others just go.
Yes, that is correct.
Then
That is,
and the
where
upper
is the
limit is for
mistake?
but there should also be a limit to everything. Right? The delay which they are, again, there a few
They're
more
all
will
right.
come. A few more will come again. As long as the process is pending, they will continue to come. In spite of the fact the panel expired long back. They should have been
I can assure
vigilant.
lordship, this is my last, I have no other matter. I can
You
assure.
cannot have, somebody else will have.
No, and if what comes tomorrow, my learned friend will not refuse.
No, 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 this is the cut-off date. I shall not come.
You cannot
While at
vouch for
14
others.
While at 14,000,
impossible.
while at 14,050, the upper limit of the candidate is 14,000. It is limit, while it is specific. It shall not beyond 14,052. Some of the candidate is, my lord,
No, what Dr. Papi
yes, correct.
apart.
Yes.
You just cannot come in at any
But
time
not
and
yet. It
say
is
that,
an- it is
yeah,
an
give me the
but-
recommendation.
But figure is 14,052. They might, and they, in their hand, my lord, more than 3,000 vacancies are still there. More than 3,000 vacancies.
That will be
Yeah.
filled up in a separate process.
No, if the recruitment notification may be published in future, that was also,
Yes, so that is a separate process altogether. This is for the earlier ones.
Yes.
This is not for the fresh ones.
yes. But my lord, since we have already recommended and we have appointment letter, similar order passed. my lord,
Please come. The petitioner seeks extension of the
cut-off date.
date of the recommendation letter issued in his favor by the West Bengal School Service Commission on 22nd November 2024. Stop. The petitioner is a job loser who lost the job in view of the judgment delivered by the Honorable Supreme Court on 3rd April 2025 in the matter of ওইটার আগের বৈশাখীটা লিখে নেবেন ঠিক আছে submission has been made to direct, not submission. The petitioner prays for a direction upon the commission to extend the validity period of the recommendation letter so that he may get an opportunity to join any school. Stop. The prayer of the petitioner is opposed by the commission. Stop. It has been submitted that the petitioner has approached the court long after expiry of the recommendation letter, expiry of the time period mentioned in the recommendation letter, and the expiry of the panel. Stop. It has been submitted that there is no direction order passed by any judicial forum permitting revalidation of the recommendation letter after expiry of its statutory time period. Stop paragraph. The petitioner has relied upon the judgment delivered by the Honorable Division Bench of this court on we met
25th November. Meeting 1512.
1512 of 2025 with IA number CAN 1 of 2025, dated 25th November 2025. Bracketed, the West Bengal Central School Service Commission and another versus Orpita Pramanik and others. Wherein the Honorable Division Bench directed the commission to recommend the name of the subject candidate, provided matching vacancy is available. Stop paragraph. On a perusal of the judgment mentioned herein above, it appears that the submission made by the commission was all considered by the Honorable Division Bench and direction was passed for issuing recommendation subject to availability of matching vacancies. Stop paragraph. Keeping in mind the jobless condition of the petitioner and that he qualified in the selection process and was recommended for in the selection process and a recommendation letter was issued in his favor. Accordingly, the court directs the commission. Now, accordingly, in line with the direction passed by the Honorable Division Bench, the commission is directed to recommend the petitioner only if matching vacancies are available after filling up of the vacant 1, 2, 4, 2 posts. ঠিক আছে? It's petition disposed of.
Grateful, extremely grateful.
Service is taken on record.
My lord, 16 is similar to item number 15.
Item number 14.
15.
15,
Similar
that
after
means After
expiry of panel, I have,
after expiry of panel and first time
yes, first time.
you are coming. Where is the recommendation letter?
Recommendation letter is page 23.
Oh, vacancy
And we, in the month of January, I have made first representation, page 25, within 90 days. Representation is.
Same order করে দিন।
Yes. Rep
Same as 615.
15. My lord, 17, my lord, it is counseling process. My lord, petitioner did not turn up in the counseling process, upper primary. My lord, similar order passed. My lord, only differentiation, my lord, I have not, my lord, I have come after the expiry of panel. This only differentiation.
After the expiry of the panel.
Panel I have come.
In this matter, opposition was filed by the commission.
Opposition.
Mukti Bishwash.
Absent candidate.
Absentee candidate. Absentee candidate, it squarely applicable on a division bench order.
To permit her to participate in the counseling process for the upper primary
Upper primary,
teachers.
after
This is also upper primary.
this is.
It is involved
Well-
in a.
Only differentiation, Mr. Shah filed that case within expiry of panel, and after expiry. Within the limit.
The division bench judgment also was during the lifetime of the panel and all other matters. These are the matters which are now coming up after expiry of the panel. That is why I was objecting, and that is
Yes, yes.
how I distinguished the.
I understood. This is Mishtu Shaha,
Yes.
9th of
I have
December.
given.
You've given a copy?
Yes, yes.
First paragraph to be deleted and the rest possibly will remain.
And my lord, here petitioners, two petitioners are there, my lord. I have given the court fees. I have given the court fees.
Both were absent.
Yes, yes, both are absentee. My lord,
Why
relevant.
two together?
My lord, together issue is similar, my lord. Both-
In that case, only one SLST matter will cover all matters.
My lord,
Why so many writ petitions
my
coming?
lord, only two has come. I have given the court fees.
It's not a matter of giving
Yes, yes,
court
yes.
fees.
Is in the documents also.
Documents page page P4, my lord. P4 page 27 and my lord 28. 27, 28. 27, my lord, is a Purnima Saren is serial number 2. Your lordship kindly turn page 27. Purnima Saren. It is a male female ST lead serial number rank 2. Serial number 2 and my lord page 28 is respect of petition number 2. Orijit Ghosh is the last candidate. Orijit Ghosh. They have been called.
General candidate.
Yes,
The other is a ST
ST
candidate.
candidate.
Hey, you mix up things.
Yes. Order is
It's a
my lord, there is
Kalana
no difference.
petition.
My non-effect is to annex at least their intimation letters. Those are not annexed.
What letters?
The intimation letters, the
Yes.
call for counseling.
Intimation letters, my lord, intimation call for counseling, I have stated in my application.
Not stated. Where is the document to show that you were called?
My lord, documents, my lord, subject to correction, my lord, since, my lord, it has not been downloaded from that. Now it is not available in the portal, my lord, in the site.
Just see, that means you were nowhere interested for the job.
My lord, rank I have, my lord,
That
panel has
maybe.
published, which I photocopy I have given. My lord, he is not.
Panel
listed.
publishing is a
yes.
different issue.
Publishing the panel is something different.
Yes, my
but
lord.
whether at all you were recommended or
No,
not,
not recommended. Call for counseling.
called for counseling.
Counseling I have, my lord. I have date I have stated in my application.
Not stating. Show me some document.
Documents, my lord, see, my lord, I have asked, my lord, they have not downloaded it from the website and it is now not
In that case, let the commission come up and say that they have
yes,
at
they
least
they can come.
they were called for counseling. You never know.
Let me check that.
Yes,
Please check.
yes. No.
লিখুন তো, the petitioners claim that they were called for counseling by the West Bengal Central School Service Commission. After their names were published in the provisional panel under first SLST 2016 for recruitment of assistant teacher in upper primary level. Stop. The panel has since expired. Stop. The petitioner prays for a direction upon the commission to permit them to participate in the counseling process. Stop. There is nothing on record to suggest that the petitioners were called for counseling. Stop. The provisional panel published by the commission to show that the petitioners were impaneled is, however, annexed. Stop. Paragraph. Learned advocate representing the commission is directed to revert with instruction, written instruction, as to whether the petitioners were at all called for counseling. Stop. Released on 28th to 8 January 2026.
Yes. চারটে ডেট অলরেডি পড়ে গেছে, লিখে রেখো, গন্ডগোল হয়ে যাবে। আজকে বিশুকে বলেছি একটা পকেট ডায়েরি দিয়ে রাখে। আর কি আছে? হ্যাঁ?
18 and 19, my lord, on last occasion, petitioners prayed for time serving the copy. This is a matter relating to the film and television industry, my lord.
The petitioners are not here today.
Here to, we have not received any copy also. As per our instruction, there
Copy
is
of what?
copy of the contempt application. 10th of September's order, wherein your lordship had dismissed the petition, therein your lordship had directed to serve copy of the contempt application, but till date we have not received.
None appears on behalf of the petitioner at the time of call. Stop. You are?
I am for the federation, alleged contender number 1 preferably, because no copy has been served, but
Learned advocate representing the federation is present.
My lord, I am for the respondent number 10 to 14.
All right.
I'm for my lord 2 to 9.
Give your appearances. Would you like to come back by giving a phone call? Or I adjourn it? Do one thing, release the matter for further consideration on 16th of February 2026.
grateful. 18, 19 both, my lord.
All right.
Grateful.
এটা অ্যানেক্সের করা নেই?
No.
এটা?
এটা কার? এটা কি 19 নম্বরের দিলেন? 19
19 same order to 18 and 19
দাদা এটা কোন কার্ডটা দিলেন?
দেখি কোন মামলা।
Twenty, my lord, I am for the petition. My lord, here, my lord, the issue relates to para teacher, my lord, upper primary
I
para
can
teacher.
see it is recorded that it is
My
pending
lord,
adjudication.
subject to
before-
correction, my lord, it is not what is pending before the coordinate bench is relating to the issue of 10%. Who can avail the benefit of 10%? My issue is, my lord, in any event, I am entitled. My lord, I initially filled up the form as para-teacher. 2020, the Honorable Court cancelled everything and directed it would start de novo. There, my lord, also I filled up the application form. Now in 2023, the commission published a notification that those who are falling within this 10%, they should upload their documents. My lord, there I failed because of technical glitch that I mentioned. Now I want, my lord, that I may be allowed to upload the document. This is the only, this has nothing to do, my lord, with the matter pending before the coordinate bench.
What my learned friend is saying is absolutely incorrect. It has already been decided that who will fall within the category of 10% para-teacher.
So the matter before the
After that-
coordinate bench is over?
No, the court decided. So after it was decided that who will fall within the category of 10% para-teachers, we started taking the documents. The challenge arose because we did not accept the documents of the non-B.Ed candidates. That is the issue which is pending before the coordinate bench.
Hmm?
Yesterday, my lord delisted 2 or 3 matters on the ground that,
It is pending.
yes, this was a non-B.Ed
No,
candidate.
no,
We have
page
his
18, my lord,
application
kindly
form.
see page 18.
We have his application form. It is blank. He has not entered his B.Ed degree. So he will be treated as a non-B.Ed.
My lord, kindly see page 18.
One-
That was cancelled, 1/8. That initially 2016, I was again asked to upload in 2021, de novo that I did, my lord. Page 18, 2012, my lord. I complete my B.Ed. This is a 2016 process.
Where is the application form where you have kept it blank?
That my learned friend has not annexed.
No, that I have not annexed, ma'am.
Well, may I show?
Then,
In 2016, my lord.
when did the recruitment process start?
My lord, 2016.
Then you may file your application by keeping it blank.
My lord, in this, at that point of time, untrained candidates, somehow, my lord, for some mistake, it was not done. But
It was
there,
a mistake.
my lord, thereafter, the entire process was cancelled. It was directed to start afresh.
But then did they call for fresh applications?
No, they directed for fresh uploading of documents in 2021, my lord. In January 2021, they called for fresh uploading of documents. Thereafter,
Assuming
yes.
that there is a direction for fresh uploading, the same will mean that the uploading will be done in terms of the earlier recruitment notification.
Yes, earlier recruitment notification, earlier eligibility criteria. It is not the case, my lord, that after 2016, I obtained my B.Ed degree.
It is prior there too.
It's prior there too. So, my lord, when there is a direction for uploading of documents in 2021, whoever have the qualification on the date of advertisement should upload those documents. That I have, my lord.
Yes.
The learned single judge, the coordinate bench, when setting aside the previously held process, the court directed that it will restart from the stage of 12-2, meaning on the basis of the online applications already received. And one of the reasons for setting aside the selection process was that we had included candidates who had kept the form blank, but they had the degrees prior to filling up the forms.
Please show me those orders.
Let me come back. Court has specifically held that this was because the rule requires that the degree obtained and mentioned in the online application form, only those
My
will
lord,
be
page
accepted.
35 kindly comes once. Page 35. The new uploading of documents, and it was allowed.
It's all right, but there is a court's order.
No, my lord. I appeared in that matter. The court, the allegation
Well,
therein
well,
was.
well, then you show me
Yes, my
those
lord.
orders.
The Justice Moushumi Bhattacharya's order, my lord, I will.
When?
My lord, any day, even no, tomorrow I can bring, my lord.
Only not today. All right, not today. Or do you want to file a report disclosing this?
There was a
document?
direction. There was a direction.
There was a
for-
direction.
Yes, ma'am.
There is a
এটা কবে
Direction
রেখেছে?
for filing.
22 তারিখ।
My lord, by order dated, my lord,
28
5
2nd of May 2024, there is already a direction.
for filing report.
Yes, yes.
Very well.
Acha, time to file the report by the commission. As per the order dated 2nd May 2024, stands extended for a period of
Lord, one Let it be returnable on the 28th, in between whatever dates my lord.
2/8. 2/8 is a long time.
The other matters my lord fixed, that is why.
28th. আচ্ছা ঠিক আছে by 16th January 2026. Today is 6th. I've given you more time. Released the matter on 28th to 8 January 2026. It will be open for the petitioner to file exception to the report prior to the adjourned date. Take this document back so that you can annex it with your report.
এটা ওনার
নামটা দেয়া আছে স্টেট রেসপন্ডেন্টস ভাস্কর হয়েছে রঞ্জন শাহ দেখুন
Did you get your other side?
One Mr. Debobroto Mondal engaged. Previously, my lord, the body was engaged. After my lord, the panel, my lord, now Debobroto Mondal has been. I talk with him.
That's not, whether I am engaged or not, I do not know. Brief is not available.
You are Debobroto Mondal.
Devat Mondal,
Is there any other Debobroto Mondal?
yes, lordships.
একজন আছে?
Bar number 16. Bar number 16. Do number.
কে আছে কে জানে, আমি তো ওখানে নাম্বার নিয়ে এসেছি।
So you called the wrong person.
আমি তোমাকে ফোন করেছি?
হ্যাঁ।
What to do? I adjourn it for this week. Not this week.
In the meantime,
Find out. Not this week.
number 16, so the bottom one is not available because at present is not in panel.
He is also not in the panel.
Originally,
Just.
he has been engaged with Debobroto Mondal.
Is Mr. Bihani still there? Then contact Mr. Bihani if he is the learned advocate who has been engaged.
Lordship, give me 1 week time in the.
Not this week, I'm making it. You find out, bring your other side, then we'll see. Yes.
But this matter,
Who are you guys in here?
My lord, I appear for the added respondent.
but
Yes.
in this matter, I am appearing for the SSC. But your lordship was pleased to direct to file us our affidavit. But it is almost ready. Kindly extend me 7 days time, Mila. We'll file the affidavit.
No, in this.
Sorry, naam.
Acha, on the prayer of the learned senior counsel representing the
Sorry.
commission. Comma, time to file the affidavit stands extended till 13th January 2026.
Your lordship, I appear on behalf of the state, I am also seeking the similar prayer.
Extension? Acha. खाली commission, comma दिए state.
My lord, I have made my affidavit ready.
Till 13th. You are the private respondent number, added
Added
respondent.
respondent in the CAN 1.
All right. The affidavit in opposition by the added respondents
Yes.
in CAN 1 of 2025 filed in court today is taken on record. Serve.
Is now.
Now serving. Let copy of the same be circulated to all the parties.
আমরা পাবো?
When are these matters fixed?
But,
Yesterday I fixed.
this is a matter relating.
But these are non-teaching, Mila.
This is non-teaching, but
Non-teaching.
I was, my lord, thinking that I should, my lord,
Hmm? No, 10 to.
This is non-teaching.
Yes.
my lord, this is non-teaching, but here also the rule is under challenge. But I have one humble submission, if your lordships kindly consider. Unlike the teachers' case, those untainted, they are getting the salaries. And their process of selections that has started and continuing. So far as the non-teaching, only the form fill-up has been completed and nothing more than that. And in a recent matter, not arising out of this, the Honorable Supreme Court, lordships might have seen, I do not know, has, my lord, inter alia held couple of 2-3 things. Number one, that because it will have an impact. So therefore, there may not be, it was, if I can just show, if your lordships kindly look at that. Mr. Bandyopadhyay would be knowing better than me because he himself appeared and made submissions.
Only that in non-teaching staff is concerned, there is no time limit.
No, I'm not on that.
Teaching and non-teaching, class 9, 10 and 11, 12, there is a time limit.
No,
But non-teaching is concerned, no time limit, but we are doing it.
yes, only because what I was only trying to say, last night I had a conference, like earlier out of 19 lakhs, only 1200 and 2100 untented that there before your lordships. Many of them, my love, after 7 years of service, someone's for medicine, variety, nothing legal about it. There is a genuine suffering they are going through. All I seek is that lordship has already,
Completion of the process within a time bound period.
all I seek this in one matter, lordship has already dismissed the writ petitions where here it is a case of 5 marks, not 10. One writ petition was filed and lordship has categorically found that no, this is the policy decisions absolutely right. So now there is no as such bar for, I'm not asking because SSC would be the best person, how much. At least I'm trying to, my lord, express the kind of suffering genuinely that
I
we are
followed
going
it.
through.
My lord, in one of the matter, before the Supreme Court, one of the counsel had said regarding the this 9 and Supreme Court orally made it very clear. They did not give any time limit or time limit on that. Despite that, my lord, we are trying to do it. Possibly, notification has already been issued and form fill up has been done. Then we will take up the, my lord, we have to publish the 11, 12. We hope by, because of one of the order we had to take time of the division bench, that will be into 8. We hopefully we will do it 15. Then my lord, we will commence this. That's really I am just submitting to your lordship.
But my endeavor is only this, if you
They kindly do not pass any order for expeditious completion, because same
No, I'm not asking any order, not at all. I'm, lordship, I'm only, my lord, seeking this. If lordship kindly have a look at this, that
in one hand rule has been challenged, in another hand expeditious may not be. In one hand rule has been challenged, and in another hand expeditious completion. That's the both are contradictory in one matter.
No,
Whoever
the submission is made by two different parties.
maybe.
Challenge the rule.
Question is,
Private respondents.
your lordship will kindly your lordship will kindly consider the scope of the petition. The scope of the petition is challenge of the rule. Scope of the, then he has to come up with another fresh. That's a fresh cause of action. He cannot ask for that in this petition. That's why I am submitting.
Well, all I am saying is this.
Either he will support me or he will support them.
Achha, list the writ petition on 28th to 8. January 2026.
Your lordship, just a one. Instead of 7 days, can we get a 2
More
weeks
days.
time? Yes.
All right, 6th, 13th যেটা বললাম, make it 20th, 20. All right. And the date is 28, returnable. Petitioners may file reply prior to
If
that
necessary.
date. If necessary, obviously. Next,
This matter is not a rule challenge. This matter
challenge is there.
date of 10 months.
Respondents.
That's good.
But Mr. Samim has struck me in another code and he is here.
That's a starting from that.
When his junior said immediately next matter he will come, and I was watching there and you were here. Fortunately, I am also watching here.
23,
I appear for the state respondent.
yes. Compassionate appointment.
May I request one thing? Because in another matter, I believe Mr. Banerjee is also there. In one passover is given by bottom number 11. If any matter, touch my junior paid for short pass.
No, Mr. Samim, I will be here now. I have to do so many matters here now.
I have to do another matter which is important, item number.
No, 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 I have to do, I was waiting there, I missed matters.
Yes,
I'll do here.
Petitioner, what is the matter? Microphone.
Petitioner applications for compensation appointment cannot be forwarded by the school authority of the school only because the filing of no objection certificate from the parent-in-law.
Yes, parents-in-law, no objection.
My lord,
Who are you?
I am for the state respondent. When school authority has to answering respondent. My lord, district inspector school write a letter to the headmistress, kindly come to page 34. My lord, directly the certain required documents they have been asked repeatedly. My lord, they have been, my lord, the school authority has not provided those
1 minute,
documents.
1 minute.
Kindly come to the page 34.
Yes,
You are once again hereby requested to submit the following documents keeping through the additional district inspector of AC Durgapur subdivision post.
listen,
The school
in that page that you are reading, serial number 3.
serial number 3. Yeah.
This the petitioner is not in a position to obtain.
Then the matter you asked the report from the district inspector of school. What is the stage of the position? Status. What is status? Otherwise, now I cannot.
And what is
tell-
what is the status? You let me know.
Lastly, my lord, after the 11th August 2025, we have not any instruction from the department. Whether my lord it has been processed or not, whether it is.
Cannot be processed because no objection is not there.
Yes.
And if the relationship between the parties is acrimonious, how do you expect that no objection will be given?
Unless my lord report is comes, my lord.
No question of the report. There is an order that has been placed before this court.
That is why I have the instruction to appear other day I handed over that judgment.
Yes.
Sir, that for that reason your lordship directed us to have
Please
the
come.
copy. They accepted but not turned up.
They have not accepted.
I believe so. Service
No.
is done.
The service is unclaimed.
Unclaimed. That unclaimed.
Acha. From the affidavit of service filed in court, it appears that the private respondents did not accept the notices sent. Where is the affidavit of service? Let me see. Last day, yesterday, you've handed over, isn't it? If I remember correctly, yesterday I have seen it unclaimed. Yes.
Yes.
ঠিক আছে। That the private respondents, না কি বললাম, that the sent by the learned advocate for the petitioner, intimating about the pendency of the instant writ petition. Stop. The postal track report mentions that the postal article remained unclaimed and has been sent back to the sender. Stop. Paragraph. The petitioner is the widow of a secondary school teacher who died in harness. Stop. The petitioner seeks compassionate appointment. Stop. Because of the non-submission of the
Legal year certificate.
legal heir certificate from the heirs of the deceased employee, the prayer of the petitioner seeking compassionate appointment cannot be processed. Stop. Next. From the submission made by the petitioner, it appears that the relationship between the petitioner and her in-laws is not cordial. Stop. It does not appear that the no objection certificate will at all be furnished by the other heirs of the deceased employee. Stop. Paragraph. Did any of the other heirs apply for appointment? Sure.
On
Learned
this, my lord,
advocate.
I have to take instruction on this score. Only one is there. Well, if you also ask me to, my lord, the query, then I have.
Why did you not take instruction in the
My
meantime?
lord, the written instruction is required. Only legal heirs point. Only the legal heirs point. Whether any other legal objection is there or not, if I go by your submission that your lordship allowed this application, then I will in difficulty.
Yes, because you are not ready with
Well,
instruction.
This is actually the only, my lord, in this point, my legal heirs means my always disputing. In the case of the compassion, legal heirs is always disputing.
Father and mother of the deceased, they are on.
When did the teacher die?
Teacher that 30 at the age of 35.
Survived by his father and mother. Father, comma, mother and daughter. Daughter is a minor possibly? Minor daughter. Stop. The petitioner earnestly requires the job for the survival of her daughter and herself. Stop. Paragraph. Learned advocate representing the state respondents is directed to revert with written instruction as to whether claim for appointment has been made by any of the other legal heirs of the deceased employee. Stop. The matter is made returnable on 21st January 2026. Stop. The
21st January.
Instruction shall be forwarded in advance to the learned advocate for the petitioner for obtaining necessary instruction. Stop. Let us see what happens.
Instead of teacher, it will be clerk.
Acha clerk, not teacher.
Careful.
Give yours.
Senior का कौन है? Senior का कौन है? Senior का ये तो
24. I prefer the student.
The issue involving this matter, my lord, is pending for the revision bench.
CPF to GPF matter.
CPF interest matter.
Acha. First paragraph will remain. Second paragraph, let the matter be delisted for the time being with liberty to mention. Next.
Kindly sees your lordship's order dated 9th of December 2025, my lord.
Yes.
Para 4, your lordship directed the learned advocates representing the state and the West Bengal Central School Service Commission to revert with instruction regarding the vacancy status of headmasters in secondary school where the petitioner may be posted. My lord, this petitioner, my lord, he got, my lord, appointed in 2013. Then, my lord, in order to come back to his residence, near to his residence, he participated in the 2016 process. My lord, thereafter, my lord, he applied for the post of assistant headmaster. He got selected. He was serving as an assistant headmaster when, my lord, his blanket order was passed and he was reverted back to the Asansol school where he was posted in his prior posting. So, my lord, assistant headmaster, my lord, he has been demoted.
My lord, subject to correction. My lord, regarding vacancy status, my lord, I don't have any issue. But my last one, lordship kindly appreciate this. Now, my lord, initially the petitioner was appointed in the year 2013. My lord, by a recruitment process, appointed in the post of assistant teacher. He participated in the, my lord, SLST, my lord, examination 2016. And my lord, in a postgraduate scale of pay, he was appointed as an assistant teacher. Subsequently, he was promoted in the post of assistant headmaster. Now, lordship kindly, my lord, have a, my lord,
in 2013, he was not the headmaster.
No, my lord, after 2000, it's an subject to correction, my lord, it's an integrated post. My lord, he cannot take an advantage subject to correction of any selection process of 2016 set at
Nothing
not by
with
the
regard to
honorable. So, my lord,
16.
his subsequent promotion in the post of assistant
Goes.
My lord, the department, the concerned authority has rightly reverted in compliance of the direction passed by the honorable apex court.
As an assistant
Yes,
teacher?
my lord, 2013.
All right.
Yes, my lord, that
Where
has
is
been
that?
done, my lord.
My lord,
Yes.
While, my lord, I was selected as an assistant headmaster, my lord, my experience from 2013 was taken into consideration.
So what? The 2016 process has been nullified. So you do not get any benefit of that process. 2013, what was your
Even
post?
setting aside, my lord, 2016, my lord, experience, I still qualify to become an assistant headmaster.
That is a separate thing. Right now, you have been
Because, my lord, the
recommended
requirement was,
as assistant teacher. You act in accordance with the recommendation if you want to, and if you don't want to, don't join.
my lord, I have already, my lord,
But he has already joined. He has already joined there.
but my lord,
So
even
nothing
setting
remains.
aside the 2016, my lord, my lord, experience, my experience from 2013 till I joined the 2016 selection procedure, my lord, I am still entitled to, my lord,
Very well. So
assistant
as and
headmaster.
when the process of filling up of headmasters, assistant headmasters will take place, you'll
My lord, I am
participate.
going back to, my lord, the 2013.
Obviously, that
assistant
is the direction
assistant
of
teacher.
the direction of the Supreme Court.
My lord, subject to
Please
correction,
come.
my lord, the Honorable Supreme Court, my lord, directed for
Uh,
reverting back to the existing school. But in
Not
the,
existing.
my lord,
Not in the existing school.
Existing sport.
In the position, in the
in the
position.
position,
Your position was assistant teacher.
my lord, this is re-recommending back.
From the submission made on behalf of the petitioner, comma, the state respondents and the commission, it appears that the petitioner has been recommended in the post of assistant teacher in terms of the post. Now, in accordance with the post which he was holding prior to his recruitment in the 2016 recruitment process. Stop. The commission has recommended the petitioner and the petitioner has joined in terms of the said recommendation. Stop. Paragraph. Prayer of the petitioner for being appointed as headmaster, since he has the requisite qualification for the same, cannot be accepted, as the petitioner never served as the headmaster or the assistant headmaster in terms of the selection process held in the year 2013. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed. Next. এটা নয় বোধহয় আমাদের।
Lord, item number 26. Item number 26, I'm for the petitioner. Your ladyship would remember, this is the matter regarding the non-disbursement of the pension, the family pension from gratuity, as well as the PF of the headmaster of a particular school. Now, my lord, in the meanwhile, while waiting for the pensions and the PF to be disbursed, unfortunately, the petitioner's husband passed away. Thereafter, his wife has made this application before the Honorable Court. Now, my lord, on the last occasion, I humbly submit before your ladyship, you would remember they had said that there were some particular objections, which objections I had already cleared on the very last occasion. And if your ladyship comes to your last order dated 25th of December, your ladyship would see you had directed them to do all the necessary works and to disburse the payments as soon as possible. Now, my lord, kindly comes to this particular document.
My instruction is that, my lord, the DI has already sent the pension papers to the deputy. But there is some wrong pay scale. Some rectification is needed. Then the DPPG again always return the file to the DI Paschim Meghani.
Now, my lord, kindly sees that particular observation containing the same application number. the application says previous objection stands. Now, if your ladyship kindly comes to page number 86, that is the annexure P4 of the writ petition. What was the previous objection? Special comments, if any, point number 13. They're saying all papers authenticated by competent authority, and number 2, PF ledger 1992 to 1993 and 1993 to 1994. Now, your ladyship kindly considers this. This is the application for the release of their pension, the family pension, as well as gratuity. There they're asking for the PF ledger as well as all papers authenticated by competent authority. Now, my lord, I have already given that and I have already submitted those things. If your ladyship kindly comes to page number 87, the ledger starting from 87, 88, the ledger is already there, and 87 to 89, starting from the year 1992, starting from 7/1/1992 till page number 89, and also from page number 90 to 93,
1 minute.
saying
The employee has expired. What is to be done?
At present, I have got instruction. The DPPG received the pension papers from the DI Paschim Medinipur on 38 December 2025. But there is an issue of some wrong pay scale. Said some rectification is needed. Then DPPG again sent the file before the DI Paschim Medinipur for some rectification is required. But at present, the file before the district inspector of the Paschim Medinipur.
Yes.
It is on a instruction.
Please come.
my lord, most humbly, if I may
Just
submit.
wait. Despite direction passed by the court on 25th November 2025, the terminal dues of the deceased employee has not been paid till date. Stuff. Learned advocate representing the District Inspector of Schools within bracket Secondary Education Paschim Medinipur submits that there are certain objections raised by the DPPG. The pay scale of the employee was not properly fixed. Paragraph. As the employee has expired after his superannuation, accordingly, steps ought to have been taken by the competent authority within the service tenure of the employee. After retirement, the allegation of wrong fixation of pay by the employer ought not to have been raised. Paragraph. As the widow appears to be suffering from penury, the court is compelled to direct a freezing of the salary of the District Inspector of Schools, Secondary Education, Paschim Medinipur, till the pension papers of the deceased husband of the petitioner is not made ready, and the pension is not disbursed in favor of the widow. The matter is made returnable on 23rd February 2026.
I'm deeply
All
appreciative.
steps shall be taken by the respondent authorities to ensure that the widow receives her legitimate dues prior to the adjourned date.
I'm deeply obliged, Your Lordship.
Next.
Direction for a report from the
Item 27 and 28, Lordship, for the petitioner led by Mr. Fith. 27 and 28, led by Mr. Fith. He is engaged before the
All right.
But if it is made not today, Millard, I'll be in a position because Millard 12:45 another matter is fixed of mine. So Millard,
Where is the report?
Millard report is there, Millard.
Has it been circulated?
Millard, that has not been circulated pursuant to my lord's order. I'll circulate it here and now.
Report by way of affidavit filed by the CBI.
I'm in no man's land.
In court today is taken on record. Stop. Let copy of the same be circulated. Stop.
To all the parties, Milord.
Yes,
To all
yes.
the
Circulated means to all the parties.
Okay.
Release the matter for further consideration on 20 January 2026.
I'm grateful, Lord. একটা কাজ করুন না, কাজের ফলে
Propon-
28 Lordship. Praying for short possible.
Why is it very difficult?
আচ্ছা ঠিক আছে এইখান থেকে 28
এটা কোন corporation?
All right, I pass it over for the time being.
20.
But our affidavit is ready.
Then file it. Affidavit
What is this? Our affidavit is ready.
Then
28 is 25. And did you circulate the copy? Please circulate
Yes,
it.
yes.
Yes.
We are subject on last Friday.
28 affidavit commission.
Item 28. Are you aware whether the affidavit has been received by the petitioner? Affidavit of the respondents?
এই যে দেখে না সার্ভিসটা দেখে না একবার
File লাগবে না।
কতদিন Milord, for as for the state's affidavit, Milord, we'll seek an extension of a fortnight, Milord.
Record an order, please.
দেখেছো তো দিয়ে তো
Affidavit in
ওই যে
opposition
দেখো
by
না
the commission filed
দেখে নাও না
on
তোকে
4th
দেখতে
May
দিলাম
is taken on record. Stop. Learned advocate representing the state seeks extension of time for filing the affidavit. Stop. Next. In view of such submission, time to file the affidavit by the state stands extended till 20th of January 20. What is the issue in this matter?
Oh, Milord, in this matter, your lordship had directed the publication of the untainted list, Milord.
All right.
Milord, the commission had went up in appeal, Milord. The order has been kept in abeyance and directed, Milord, and Milord suggested that the matter be heard finally.
All right. Released on 2/8. It will be open for the petitioners to file exception to the same prior to the urgent date. Yes.
Yes. Transfer to.
তুমি আছো স্টেটে?
Now, the petitioner was appointed as assistant teacher in his school of Habra, 24 Pargana in the year 2013. 2021, he was transferred to a school at Bhavanipur.
29.
Now, after 2 years in the 2023, he was transferred to a school at Bajbaj, Rajipur High School, because he was surplus teacher in Bhavanipur school. Now, after 2 years, in April 2025, suddenly we have withdrawn such transfer order and revert back the petitioner to his earlier school. That is Bhavanipur. The Bhavanipur only 160 students and 19 teachers. So there is already 15 surplus teacher, which petitioner is the 16th surplus teacher. But he will be transferred again. Whereas where he was working at Rajipur High School, there is requirement of teachers.
Commission. You are for the board. Recommending authority is the commission.
Yes,
Milord, I am appearing, Milord.
Yes.
Milord, your lordship kindly come to page 31.
1-3.
31, Milord.
All right.
Kindly see that. the Deputy Secretary to the Government of West Bengal to the Chairman West Bengal Central School Service Commission. My lord, the recommendation for transfer in terms of departmental notification dated towards the rationalization of teachers working there has school. The undersigned is directed to state that the previous memos number of this department are hereby cancelled till further orders, and the transfer of the teachers in terms of those orders is withdrawn hereby. Ever since it has been cancelled by the state, we have to withdraw the order. That is at page 33.
Where is the state? Where
For the
is the
state.
state? Yes. Submission of the petitioner is.
A similar case was, my lord, taken up, my lord, in one of the matter. A similar case was taken up, my lord, and the same submission was made by the, my lord, commission, my lord, and Justice Shagatu Bhattacharya was pleased to, my lord, dispose of the matter, my lord. I will refer the, my lord,
Give the number, please.
my lord.
If the petitioner is a surplus teacher in the school, then what is the use of recommending her over there?
My lord, that recommendation has been cancelled, my lord. The transfer recommendation has been cancelled.
That
Now,
means she reverts back to the earlier school where there is.
no, she was.
Where there
That is there, my lord.
plus
That is there.
what remains. You cannot take these teachers to act as ping pong balls from one school to the other. This cannot be done. Check up. Where is the order?
My lord, it's WPA, my lord, 20462 of 2023, my lord.
20462 of 2023.
The order was passed on, my lord, 16/4/2025.
16th April 2025's order. Please find out. What did the court direct?
The court, my lord, since from the report, my lord, I'll read out the, my lord, relevant portion, my lord.
That means there was a report.
My lord, in the present writ petition, it transpires that on behalf of the West Bengal Central School Service Commission recommendation, memo was issued on 18th April 2023 in terms of the memo of Deputy Secretary to the Government of West Bengal, being number such and such dated 31st 2023. Since aforesaid memo dated 31st March 2023 and another memo dated such and such.
Just wait.
dated, my lord.
I'll read it. Tulun. ठीक है तुलुन आरो तुलुन. Setting aside the recommendation memo issued on behalf of the commission, transferring. But then I do not know whether the facts will be the same over here.
But I don't think the facts will be the same, my lord.
It differs. The transfer order based on this memoranda have been withdrawn.
My lord.
Setting aside the recommendation. Right. Here the recommendation has already been withdrawn.
My lord. Then let me come back with a further instruction, my lord. Then I'll come back with further instructions.
Respond number 11, 12, my lord, I would like to draw your lordship attention to page 36 of the application, my lord. The entire scenario.
1 minute. 11 and 12 is who are they?
Where the petitioner was transferred.
All right. From where he has been transferred?
From page 36 of the application, my lord, there are more than 1,000. Out of which only 2 are physical science teachers.
And petitioner is a physical science teacher.
They have made this representation to the West Bengal Board of Secondary Education.
Please come. The petitioner challenges the order of cancellation of the transfer order issued in his favor. আচ্ছা কি বললাম the petitioner challenges the challenges the কি বললাম cancellation dated 11th April 2025. Cancelling the transfer order which was made in the year 2023. Stop. Paragraph. Submission is that the petitioner stood transferred in the year 2023 on the ground of being a surplus teacher in the school. Stop. On cancellation of the said order of transfer, comma, the petitioner is required to be reverted to the previous school where he is still a surplus teacher. Stop paragraph. Submission is that the school where the petitioner is currently working
No, my lord, I
as
have joined.
Acha, has joined.
Because they asked me, let's
working.
join, my lord, they will cancel my recommendation.
All right. Dale, the school
Was what?
where the petitioner was working on transfer
My lord.
has deficit number of physical science teachers. Stop. Prayer has been made to set aside the impugned order, cancelling the transfer order. Stop. Learned advocate representing the school where from the petitioner has recently been transferred submits that there are more than 1,000 students in the school with how many physical science?
Teachers.
With only 2 physical science teachers. Stop. The school is in acute need of teachers teaching physical science. Stop. Paragraph. The learned advocate representing the state, is directed to revert with written instruction from the district inspector of schools with regard to the vacancy position of the Ramrik
Ramrik at Bhavanipur and Rajipur at Palpajbaj.
Ramrik institution within bracket HS and the Rajipur High School within bracket HS with regard to the subject physical science. Released 21st of January 2026.
Grateful, actually. 21st. Report लेने को उससे.
Hindi.
From the monthly list, item number 168.
Yes.
Matter, I am for the petitioner. And asking for no objection certificate from my parent school.
Microphone.
I am requesting the school authority to issue no objection certificate for my transfer. Till today, the school authority did not issue any no objection
Did you
certificate.
apply in the portal?
Yes, yes, sir.
Where is it?
On the ground, the single teacher.
Where is the rejection on the ground that you are?
No, they have not issued. It is rejected. They have not issued any no objection certificate. The application is page 14.
But there is a prescribed format.
There
There is a prescribed format for
page 19.
yes.
They have not issued.
All right. Please come. The petitioner seeks transfer. Stop. His application made in the prescribed format before the school authority is pending consideration. একটা usual order আছে ট্রান্সফারের পেন্ডিং বিফোর দ্য স্কুল। হ্যাঁ, একটু দেখে নেবেন তো। Dispose, they will consider.
With it,
check up the time. Possibly it is 8 weeks or something.
At 169, I am for the petitioner. My lord,
I'm
I
for
have
commissioner.
applied in the portal
on the ground of distance, my application has been rejected by the school authority on ground of, my lord, below 10%. I am not within the 10% zone. My lord, similar, my lord, it has been rejected 2021. My lord, the staff strength may, my lord, change at the in the in my lord, last 4 years.
Where is that?
My lord,
Show me the rejection.
yes, my lord. My lord, rejection, your lordship may, my lord, turn, my lord, page number 20, kindly turn page number 26. And my lord, I am only playing, my lord, in these conspectus, let the petitioner be given liberty to apply a phrase and which needs to consider in accordance and similar
Yes.
issue as, yes. Jalpai.
All right. এই অর্ডারটা হবে, এই প্যারাগ্রাফটা হচ্ছে না, ডেটটা এখানে চেঞ্জ হচ্ছে, আর এখানে শুধু রিট পিটিশনটা ডিসপোজ হচ্ছে, কানেক্টেড অ্যাপ্লিকেশন নেই। ডিসপোজড।
I'm for the petitioner. My lord, kindly come to page 76.
I'm for the state.
70. Petitioner made transfer application on medical ground. My lord, kindly see the DI's observation, not recommended as it is not under the sixth mentioned disease. First of all, DI is not the recommending authority. Secondly, in my case, medical authority, despite its recommendation, DI sat over an appellate body of same.
Where is the recommendation of the CMO?
Yes, ma'am. The previous coordinate bench allowed me to submit a supplementary affidavit. Possibly it is with your lordship's record.
Yes.
Kindly see the CMOH report. It is first is, my lord, BMOH report at page 15. Both the authorities have allowed. My lord, kindly see page 15, 15, last annexure. This is the BMOH report, my lord.
Yes.
Then, my lord, kindly take the previous page, the final CMOH authorities medical examination report. Kindly see the opinion. NOC may be issued with serious complications.
Not serious.
I do not understand, my lord, what is written, but it has been recommended. But despite that, the DI has sat over an appellate authority for the CMOH reports, which is not permissible as per the rule. Rule says that as per the CMOH's report, DI has to forward it before the commission. That is why, my lord, the previous coordinate bench allowed me to place this medical document. I obtained this document by way of RTI. My lord, may I show the rule for your lordship's kind?
Yes. What is the stand of the state?
My lord, due to, my lord, that confusion, my lord, the concerned authority, my lord, requested the CMOH to clarify that whether the said disease is included in the list of the, my lord, criteria that.
CMOH got to do with whether what disease is included in the list or not. CMOH will give his independent opinion.
My lord, but this opinion, my lord, is not conclusive, my lord.
No, my lord, serious gynecological problem is a disease.
Anything, and that's why, my lord, as per the report, my lord, I'm reading it out, my lord. The office of the DIS AC Malda, through memo number such and such dated 11/7/2025, requested the CMOH Malda to issue conclusive medical report.
Where from are you reading this?
My lord, I'm showing you, lordship.
There cannot be revisiting of the issue. Serious gynecological problem is under Rule 4A.
My lord, in the
It is an
similar situation, your lordship, my lord, already, my lord, sent again, my lord, since it is 2021, my lord, today we are 2026. So, my lord, your lordship kindly direct the CMOH subject to your lordship sanction to again, my lord.
Since there is already a report and my application is, it is already conclusive report.
As it, which paragraph were you reading? 6, the office of.
6, my lord.
They requested CMOH to issue conclusive medical report in connection with the transfer prayer. To whether to be considered. All right, 11th of July 2025, this request was made to the CMOH. Where is the CMOH's report?
It is not yet received.
Well, possibly
What
that
do you
was,
say?
that
Not
was,
yet received
well,
from,
that,
July, we are in January 26, it has not been received. How long will the CMOH
Status I
stay?
cannot say, my lord, right now, my lord, if your
This
lordship.
is your instruction.
My lord. My lord, the letter is at, my lord, R2, my lord, if your lordship, my lord, kindly turns.
Maybe the letter is there, but what is the follow-up?
My lord, I shall take further
well, this
instruction.
submission was not accepted by the previous coordinate bench. That since it
Yes.
is, there is already, yes, because it was placed before also. My lord,
not
just a minute, just a minute.
That's
My lord,
what the court.
no, just a minute, my lord.
To take,
The DI has refused on the ground that serious gynecological diseases does not come within the 6 diseases, which is apparent from page 34. Kindly take page 34, bottom portion. Can the DI, I pose this question to myself, can DI say that serious gynecological disease is not covered when it is clearly given? Kindly take page 34, bottom, my lord.
Yes.
Any incumbent or his or son, daughter, spouse suffering from malignant disease, several heart disease, renal failure, thalassemia, replacement of organs, serious gynecological disorder. So, my lord, the first contention of the DI in the status, that is at page 76, is wrong. The DI said that this disease does not come under the serious 6 diseases as per rule 4A. Itself is bad. Moreover, CMOH has recommended.
This mentions only about a serious disease, not a gynecological or disorder. This has not been mentioned.
No, 4A mentions, my lord. 4A. Kindly see 4A rule.
No, your report doesn't mention.
Yes, it says, kindly BMOH report, kindly take BMOH report. In the
BMOH report, it says it's a serious disease, not gynecological disorder.
Yes, my lord, kindly see the
That is why
medical
within
formation. No, they're not, that is a, kindly allow me, my lord. Kindly
Please show me what is the status, updated status. Please come.
well, today the situation may be different. I am relying upon this document. It has been recommended. The CMOH writes
If
that.
the situation is different, if it is better, you get well, then that is good for you.
But my lord, the transfer, I am entitled for the transfer on this document.
Entitled to the transfer relying upon a medical report which is 3 years back.
No, I made this repetition of 2022, my lord.
Maybe, but then we are in 26.
Yes, but the repetition of 2021 report, kindly based on this report, I may be considered.
Report of the District Inspector of Schools.
CMOH writes NOC may be
You
issued.
do not want to get better. You want to hold on to that disease.
No, disease I cannot say on that, my lord. Disease I cannot say that.
Acha. The report of the District Inspector of Schools, Secondary Education, Malda, dated 16th July 2025, handed over by the learned advocate representing the state respondents, is taken on record. Stop. It appears therefrom that the DI, Vide communication dated 11th July 2025, requested the CMOH, Malda, to issue conclusive medical report in connection with the transfer prayer of the petitioner. Stop. Let the report of the CMOH, Malda be placed before this court on the adjourned date. Stop. Released 21st January 2026.
Grateful.
The grounds given come under that possibly. I do not know. And CMOH will. 21st January.
Well, I'm appealing for the state responding. This is also general transformer.
Vasefali Mondal. Please call him. Somebody please call. His phone number is here. Take it from. Yes, call him. Please call him. I'm passing it over. 172?
172.
172
Rejected by a school.
Page 28, my lord, kindly see.
Yes.
The prayer of the transfer application was returned up to the stage of School Service Commission. School Service Commission returned it back on the ground that school is not available due to low rank of the petitioner.
This is of 22.
Yes, ma'am.
Please come. The petitioner's prayer for general transfer stood rejected by the West Bengal School Service Commission on the ground that his rank is low in the preferred school applied by him. Stop paragraph. It appears that the rejection was made in February 2022. Stop. The petitioner insists, no, not insists, the petitioner seeks, the petitioner intends to proceed with his application seeking general transfer. Stop paragraph. As the last rejection appears to have been made nearly 4 years back, accordingly, leave is granted to the petitioner to file fresh application seeking transfer. Stop. In the event such application is made, comma, the same shall be considered by the respective authorities in accordance with law at the earliest. যেখানে বললাম না liberty is granted, ওই জায়গাটা লিখুন the writ petition is disposed of with the observation that it will be open for the petitioner to apply for transfer. Disposed.
On 73.
Yes.
All time for the petitioner. Pending before the school authority, they returned it back on the ground, there's a shortage of teacher.
Staff deficiency has not been fulfilled. Please come. The petitioner's application seeking transfer stood rejected by the head of the institution on 24th January 2022 on the ground of staff deficiency. Stop. As it appears that the rejection is nearly 4 years back. তারপর থেকে আগেরটাতে যা দিয়েছি same.
I'll have to apply afresh.
Apply afresh. Disposed.
Item number 174.
Yes.
Kindly take page 29. I have applied for transfer on medical ground of my wife. Serious gynecological disorder as assessed by the government doctor, government hospital doctor of the SMC. Page 29, 30, 31. All are the report. On the basis of that, managing committee already forwarded the application to the district inspector of school SC. Kindly see the DI's at page 62. He has assessed at page 62. Poshun Kumar Batable transfer eligibility, no need to CMA certificate for spouse, have any serious illness, no CMA report as per the sentence.
Where is the report of CMOH?
That is with the domain of them. Now, kindly take the order passed by the coordinate bench in the 15th of July 2025.
This matter?
What are, yes. What is the report of Justice Rai? Whether DI can make himself is the authority to
No, he is not the authority. Where is the CMOH report?
Nothing has been discussed. He said DI report that disease is not enlisted one.
Lord, we have been directed to file to produce the report of the
CMOH.
This is the
report. CMOH report.
CMOH report annexed.
Let me see.
DI's report.
Give a copy to him.
Copy there.
It has been.
So August 22, it's not an affirmed copy, but then it is signed on 14th of August. Why did you not hand it over to him? He could have taken instructions in the meantime.
It was not sent to the CMH at all.
Yes,
as per the version of the DI.
The request to produce medical report in favor of Suparna.
Lord, kindly take me, Lord.
Give a copy, give a copy.
Yes, given.
Where is the CMOH?
Taking the next year, Lord.
Art 2.
Yes.
When the patient came to the disease is not enlisted.
Medical board of the supervisor of the hospital within memo number 35 regarding transfer of teaching and non-teaching staff. Kindly read the second paragraph. This is to note that as per notification of Kolkata Gazette by School Education Department, Government of West Bengal is such and such an incumbent can apply online in the designated portal for transfer if he or she suffering from either those are listed diseases. Now, therefore, by examining
The CMOH,
yes.
what is the
Not enlisted.
1 minute, name of the applicant, ID,
As per the aforesaid
personal,
column number 61 is
she is, so what is her name? Spouse's name, Shuparna Botokbal. Shuparna Botokbal. Prashan Kumar Botokbal. Generalized tonic-clonic seizure. The disease is mentioned, page 6.
Page
6 of
Six.
the report that has been filed.
Yes, not
It is-
enlisted.
Not enlisted is different. Thing is diagnosis. What is the diagnosis? Generalized tonic-clonic seizure. This is what has been mentioned by the doctor.
Yes.
Right? Whether this fall under the serious gynecological issue or not, this the doctor only can say.
Yes, that
Lord, if your lordship kindly take page 29.
In annexure R2.
I am
29.
looking at R2.
Yes.
29.
R2 vis-a-vis not page 3, not the table.
29 and to 31. It is a report, bulky uterus with small infused.
Listen, your report will not do. It is
My
the
lord.
CMOH report that has to be
Correct.
taken into consideration. CMOH is saying that it does not fall within any of
My lord,
these
subject to
things.
correction, my wife was not sent to the CMH after it was forwarded to the DI. That is the.
But then it is proper. You are not properly instructed.
Yes,
See
today
page
today
5.
morning I have.
See page 5.
Yes. Page 5.
Before that, you kindly see page 3. Kindly see page 3.
Following personnel appeared before the medical board. After examination, the board has come to conclusion of the following decisions. But whether the diagnosis was done relying by checking up the patient,
No, she was asked
Called
to Milord,
page 3.
she was called page 3, your lordship kindly.
the patient appeared,
No, Milord,
কোথায়?
probably not, Milord.
then
Kindly see page 3.
6th of August.
6th of August, she has been called, Milord, he has been called.
who, he or she?
She.
Suparna.
Where is the document to show that Shuparna was called?
What is that particular document?
Which document?
Page 3.
Page 3, this document.
In obedience to the order
Huh?
requested to funding the medical report
Fund
of such.
medical report. Where is the document to show that the lady was examined by CMOH?
Obliged.
Please come.
And it is a
The
25.
Seeks transfer on the ground of medical illness of his spouse. Stop. Paragraph. The district inspector of schools rejected the prayer of the petitioner for transfer with the observation that the disease of the petitioner's spouse does not fall within the enlisted illnesses
Milord, probably she appeared.
pursuant to which transfer order may be passed. Stop. Next. The petitioner has annexed documents to suggest that his wife suffers from serious gynecological disorder, which is a valid ground for transfer. Stop. Paragraph. From the report filed in court today, signed by the District Inspector of Schools within bracket SE, bracket close, Purva Mednipur,
Yeah, indicate one thing, sir.
dated 14th of August 2025, it appears that The
Lord, one thing may I indicate to that? Lord, if your lordship kindly takes Lord, annexure up to.
Page 4 once.
Lord, fifth paragraph, fourth paragraph. The sentence starts therefore. Has your lordship got it, Lord?
yes,
Therefore, by examining the patient, the medical board came to the conclusion that the disease she is suffering from is not enlisted as per aforesaid Calcutta Gazette. In Ushashri portal, there are only option for electronic selection from the.
yes, yes, this I have followed.
She has been
So
examined.
from here you say that she has been examined.
She has.
All right.
Let there be an affidavit. There was a direction for
Correct,
the filing affidavit. When I am to disclose regarding reply also.
It appears that the medical board of the Purbo Mednipur District Hospital has opined that the wife of the petitioner is suffering from generalized tonic clonic CLONIC seizure page 6 and page 7 banan jodi in case dekhte hoy, which is a disease not enlisted in the transfer rules. Stop. Next. Learned advocate for the petitioner asserts that the wife of the petitioner was never examined by the medical board. Stop. The report forwarded by the superintendent of the hospital dated 23rd February 2022 mentions that the petitioner appeared before the medical board for medical examination. Stop. No, not the petitioner.
This is addressed to CMOH for, but that has not been done. Kindly see that addressed to by the superintendent to the CMOH for treatment, but that has not been conducted. That is my contention.
What for?
Page 5.
Page 5.
To the Chief Medical Officer of Health, Purbo Midnapur. That is one of the member of the CMH, their board.
Yes.
Now it is forwarding by next page Superintendent of District Hospital.
Yes.
For conducting.
No, no.
Or
Subject at the top, it is written opinion of the medical board for transfer.
Yes.
But problem is, here it is mentioned, the following personnel appeared before the medical board. So what does this mean? Did the patient appear? Did the petitioner appear? I am confused. I do not know.
My client's wife did not. Just now at 11 a.m. I have asked him whether his wife has been called for further medical verification by the COMH or board. Nothing done.
Never ever.
Never ever.
Not even in 2022.
No. As on the filing the date of
This is the column, table.
filing the, let them produce the document.
Kindly see the table.
No,
sir.
nothing done. I have
Your name of the
with the
patient,
instruction
name
today
is-
morning at 11 a.m. Just now I called my petitioner whether she was called on for any medical verification by CMH. He said no. And
Any
if
government hospital, even if it is not CMOH, any government hospital.
initially by the medical doctor of the CMC, first time, page 29 report of the medical authority of the government. First time. Now kindly page 29, kindly see. Thereafter no
One
nothing.
minute, page 29 of the
Yes,
petition.
who is the doctor, consultant gynecologist and obstetrician, associate professor of Midnapur Medical College and Hospital. He's
No, but then this is in a private clinic.
Private done by him.
It is done by you. It is not.
I believe so. It is the doctor of the AMC as per rules. Otherwise, it could not have been sent. And
Lord, kindly sees the.
It doesn't appear
let
that.
there be another medical test.
Kindly sees the table. Second table, your lordship, on the second column, name of the patient. And name of the patient is.
Patient is there, but it has not
Applicant
been.
and patient, 2 columns are there.
Let there be another
Two
test.
columns, applicant and
If
patient.
that is so.
23rd February 2022 mentioned that now না এটাকে রিফ্রেশ করতে হবে the opinion of the medical board sought for by the superintendent of the Purva Mendipur District Hospital was in the month of February 2022. Stop. Nearly 4 years have elapsed after the alleged medical examination of the petitioner's spouse. Stop. As the petitioner insists for transfer and contends that his wife is still suffering from the medical disorder. Accordingly, the CMOH Purva Mendipur is directed to conduct fresh medical examination of the petitioner's spouse to ascertain as to whether she is suffering from any medical disorder. For which the petitioner may proceed with his application for transfer. যেখানে medical disorder বললাম না সেখানে enlisted medical disorder.
As per notification of the Kolkata my school education department.
Acha. The matter is made returnable on 23rd February 2026. Stuff. The report of the medical board. No, not board, the CMOH shall be placed before this court on the adjourned date. Stuff. The petitioner is directed to cooperate with the respondent authorities for conducting the medical examination of his spouse.
Get much obliged to you. And venue or date will be fixed by them, I believe. Get
আচ্ছা একটা লাইন অ্যাড আপ করে দিন তো the date of the medical examination shall be intimated to the petitioner at least 3 days in advance.
obliged to get full.
Report by CM.
Much
Report by CM.
171 password matter.
Just wait, you were not there. And now you come up and say 171. 175.
But here Lordship has already passed an order. I was just saying in item number 173, where my lord, the application for transfer was made long back in 2021. Kindly see, my lord,
Rejected for what reason?
my lord, said to be out of 10%, but which is not true. Page number 21.
Page 21.
It is 173. You've checked up?
I'm sorry, ma'am. Yes.
173.
Yes.
আচ্ছা 173 দেখুন তো আপনি নিয়েছেন?
Only one thing, my lord, I'll just request your lordship to add in one as has already fallen from your lordship. No. In 173, the reason for rejection was different, but the later part of the entire order.
আচ্ছা later part. আচ্ছা where is the rejection? Let me
Page number 21.
21. The application of the petitioner
Serial number 1.
transfer stood rejected as the petitioner did not fall within the 10% of the teachers eligible for transfer. একটা usual order এর copy দিয়ে গেছিল সেইটাতে পাবেন দেখবেন 10% এর একটা ইয়ে আছে বোধহয়
But in
169
173 lordship directed that once again to apply afresh.
একটু দেখে নেবেন তো
যেহেতু এটা স্কুল অথরিটি
আর
and
তারপর
only
173 তে বলেছি the said order is dated একটু দেখে নিন in April 2022 nearly 4 years back
yes
তারপর থেকে it will be open
yes
for the petitioner to apply afresh seeking transfer
because
ঠিক আছে?
only one thing I just request your lordship to add that suspension of the portal matter should not be a bar so that I can make the application offline. That's it.
When you make the application obviously it is offline
But
আগেরটাতেও
otherwise they will
করে
once
দেবেন।
again do and I'll once
ঠিক
again
আছে,
come back. to
আগেরটাতেও করে দেবেন অ্যাপ্লাই যেখানে বলেছি সেটা হবে অফলাইন একটা ওয়ার্ড শুধু অ্যাড হবে অফলাইন
And but it should not be a bar, my lord. The suspension should not be a bar. Kindly, my lord, mentions that.
and suspension of the Uchshosri portal will not be a bar
Yes.
on the path now will not stand
Yes.
in the way of the respondents to consider the application seeking transfer.
Grateful, my lord.
এটা উপরের গুলোতেও দিয়ে দেবেন yes 176
But the next matter your lordship will see, it is a 2016 SLST matter. So, my lord, I think, my lord, my job is there no more, my lord.
Should the petitioner's application seeking transfer has become infructuous as the job of the petitioner has been terminated in view of the judgment passed by the Honorable Supreme Court on 3rd April 2025 in the matter of give the name
Boishaki Bhattacharya. Yes, my lord.
বৈশাখী ভট্টাচার্য একটু দেখে নেবেন প্রদীপের কাছ থেকে পেয়ে যাবেন 177
Grateful.
177, I am for the commission.
Has already been disposed of.
oh this has been dismissed
Dismissed actually, my lord.
আগেরটা হয়ে গেছে এইটা 177 বললে হয়ে গেছে
177 হ্যাঁ 177
disposed হয়ে গেছে
ডিসমিসড হয়ে আছে
এই তো এখানে all right yes the passover matter
But before that, not may I enter once, where is that 174, item number you're working with that medical examination? And the report is kept and because today we are.
yes it is on record yes
But this is an application for transfer, but this was not considered previously. And only on the ground of single teacher, but district inspector of school, my lord, and for temporary attempt was made for temporary alternative. But that was failed. Then I moved for this Honorable High Court. Then the Commissioner of School Regulation passed a reason order.
where is
As
it
per Lord, page 72.
yes
Page 72 to the relevant fact.
is this under challenge
No, it is
Then-
supported my case, Lord. But that was not implemented by the DI.
you want implementation
Yes,
of
yes,
this?
yes, exactly, Lord. And several division and judgment also in the same line, Lord. The last paragraph, Your Lordship, page
yes to
73.
provide fresh proposal for suitable local arrangement
Having considered the fact, the
tran-
first 1 to 12,
should
it appears.
she
that
apply for transfer once again in the
Not merit, on merit. However, she could not.
no sir
My
you
lord.
have not read the last 3 lines
Yes, yes, Lord.
you have been directed to apply afresh
Yes,
for
yes, yes,
transfer
that-
you
that-
did
I applied.
you applied
Application?
may thereafter be and it
that
has
is
not
not-
been disposed of
That was, Lord, returned back by the school authority, so on the ground of single teacher.
where is that
Page Lord 80, Lordship, can you come to page 80? Page application I have made,
yes
page 80.
page
Sir.
80
Yes, Lord, it is online track application transfer.
Page 81.
Successfully, page then 81.
cannot read
Cannot read, but the next paragraph it is.
single
Page
teacher.
82. Page
Very well.
82, your
Please come.
application transfer.
is returned back.
Single teacher. আমাদের একটা
The
না
division
municipal
bench
order
judgment is there,
আছে।
no?
Sent to the DI also. Application has not, was
I-
not sent to the DI.
Kindly see
Correct.
the online application, my lord, online
Kindly
application.
see the prayer is for the NOC from the school.
Yes, it has to
It
be.
is not
There
anywhere.
in the school.
It is
Yes,
not
I can
anywhere.
understand. Page 81. See
I've seen
the
it.
chart. It is from the head of the institution. It has been returned.
Yes. That point cannot be
Single
sustained.
teacher.
Single teacher lord, on the ground.
Pending
Division bench
before
judgment
this
is there,
school.
if your lordship.
Disposed.
Lord, may I place the division bench judgment is there?
No,
that-
nothing.
That is not, that cannot be the ground, single teacher ground.
Yes.
Point.
হয়ে গেছে তো সব?
This is not, may not be the ground, my lord.
While I was sitting here, because of the weather today, I got the inspiration that I thought I would begin my argument with akin to the weather that we are experiencing in couple of days. Well, when the matter started, it was a completely foggy situations. In a sense, nobody knew
What is going to happen?
exactly how much percentage of freshers will be getting it. Now today, fortunately, I am in a position there is enough sunlight.
Good.
The result of the sunlight is,
But I think Milord, Mr. Dhar will take today. Can I come back on other day?
I have concluded only few
Yes.
things were left out, so I will not take much time.
But the state advocate
There
general will
are
have.
others. There are others. There are others.
There are others. There are others are
Just
there.
what is that there?
Milord, can I come back on the next day?
All right.
With your lordship's leave, I am leaving.
Yes.
Lordship.
What is the sunlight?
Yes, sunlight. Okay, just
Yes.
well, there is, before Lordship look at it.
And this data is collected from the website of the commission.
Yes, they have got it, and it can be verified. If I am wrong, I don't think.
No, but then this is from the commission's website.
I believe.
Where from did the figures come?
Well, because they are not allowed. Can one person be allowed? Can one person become?
Did you not inquire where from these figures
These
came?
all times, whatever figures they have given,
Huh.
it was found to be absolutely right. But I really do not know. Must have been but like vacancy positions,
But
how
that is
numbers.
disclosed.
Yes.
Hmm.
Website থেকে data নেওয়া হয়েছে, huh? But this is right. Websites.
Hmm.
My lord, I termed it before when I show this. The entire argument had been that there is a possibility of prejudice, my lord, which is definitely a very good argument. Now, any very good argument can become or may lose that goodness of that argument if the fact remains completely different. Now, this fact is this. In class 9 and 10, the total number of candidates called, this calling is 1.6 is to 1, 39,207. Out of that, freshers represented, my lord, 27,000 and odd, which is 68.89%. So basically they are beaten. And the in-service were 31.11%. That's I'm saying in 9-10. 11-12, my lord, if I go by percentage, because percentage gives us a, my lord, clarity. The freshers are 49.4 and in service we are 50.so. So in 11-12, we are little better in that sense. And overall, if lots of look at that, overall freshers in the entire these competitions, they are 62.25%. They have been called. And we are representing 37.75%. My lord, here the logic as my respectful submission before your lordship. Now, first 1 and 2, this is just the figures. 3, overall freshers constitute 62.25 of all candidates called 37,000 out of 59,447. Now, if experience marks were prejudicial in service candidates, would dominate. The actual data shows the exact opposite. Now, written examination, that I began with not because I didn't have the data on that day. But I was trying to, my lord, persuade your lordship that 60 marks, that's the dominating factor. Now, factually is found to be possibly, my lord, that I was right. Written examination, 60 marks remains decisive. Freshers who performed well easily overcame the 10-mark experience advantage. The contention that the freshers are prejudiced is not supported by facts. So 25 rules Therefore, my lord, this is my submissions. This is a fair, balanced, and constitutional. So if I can just say one sentence more on this, that I am only trying to delink all other submissions based on a hypothesis, it can stand for any other factual scenario. But in this factual scenario, where skill was given some weightage, in reality, it has not done that kind of bottleneck situations that they are not able to compete. So this is my respectful submissions. So even if there is an excellent argument, there is an excellent judgment which is contrary, but factual position shows that there are, if I can use this term, more intelligent, more meritorious freshers. They have come, and this is the percentage which I have done, my lord. My lord, only few things are left over. Later, though, first 10 to this. Extension. Oh, that will come later. 10. Put it, no? Put it. Well, this is a direct judgment 2000. 2014 6 SCC 644 Joginder Pal, paragraph 23. This defines, in fact, I have brought the Blacks and also Oxford. I found that inspiration was got from this both, and that the Honorable Supreme Court have found this. Paragraph 23. What is the meaning of the word tainted? At 23. In this backdrop, the High Court rightly covered these persons as tainted persons, ascribing following meaning to the expression taint. Now, this is the meaning. The word taint, as per the new shorter Oxford English Dictionary, can be expressed to mean a trace, stain, or a blemish. It denotes some evil quality, a contaminating or corrupting influence. It can lead to mean and imbue with anything objectionable, or to contaminate or infect. The word taint, when used as a verb, means dishonest, destroy integrity, vitiate, tarnish, and degenerate morally. Well, why? So, one word, if Lordship look at the components, these are the different, I would say, somewhat synonymous kinds of words. Unless and until I have been specifically found to be dishonest, it's not a simplicity of violation of anything. Possibly the Honorable Supreme Court, my lord, has would not use the word taint. So therefore, all these words, dishonest, destroy integrity, vitiate, tarnish, and degenerate morally, all in one term, that's, I have to be corrupt enough. There has to be some contributions. There has to be something which shows that it's not a mere violations. I have lost the integrity. I am dishonest. And since, well, this is the, if Lordship kindly take the Black's Law Dictionary on, this is 10th edition. I have taken the first page, edition page, and the relevant page, 10th. Page number 1681. Taint, to imbue with a noxious quality or principle. 2, to contaminate or corrupt. 3, to tinge or affect for the worse. Originally, to taint was to affect only slightly. Today, however, to taint is normally to affect seriously for the worse. So maybe one day, once upon a time, taint was a little bit, but now the dictionary shows the historically it has to be something. And
Serious.
Yes, my
It
lord.
has to be something serious.
Serious. My lord, because that's the reason, my lord, the loss of integrity, the dishonesty. If I can use, my lord, in a very simple terms, some contributions on my part in the corruption. Just because, if Lordship kindly, my lord, I was also thinking in this way. Well, if there is a selection process, I'm a part of the selection process because I am one of the candidates. If the selection process corruption happens, then corruption happens because of involvement of some persons, maybe persons from the side of the authorities and the persons from the side of the who have got the job. In both cases, ultimately they create, my lord, all these things based on the components. So leaving aside the authority part, there has to be involvement as far as I am concerned. If I'm a candidate, that I have lost my integrity. It is not enough that I have participated in a selection process which lost integrity. That's not enough to call me as a taint. I can be called to be a taint if I have lost the integrity, if I have become dishonest, which, my lord, so the Honorable Supreme Court have mentioned that specifically. It's not just a violation. The rule prescribes within such time something has to be done. So authorities have done beyond that. It is not just that. There has to be something more than that. No, but well, there was one point but in one of the writ petitions was taken. Well, may I also, because after the last day, whatever happened, there are 2 orders by the Honorable Supreme Court. Like earlier situations, there had to be, everything had to be done by 31st. But now this has been extended up to 31. It might not have been brought to the notice of your lordship. May I just hand over that also? This does not touch with the merit of the matter, but just to say that if lordship kindly take this order dated 18th December, this miscellaneous applications are ordered granting extension of time for completion of the selection process concerning assistant teachers for 9 and 10 on the one hand and for 11-12 on the other till 31/8/26 or in the event the process is completed prior to that date. So sealing is now August. Till the said date, whichever is earlier, completion of the selection process would mean culmination in issuance of appointment orders. But thereafter, we make it clear that the untainted teachers already appointed who were permitted, the orders I already placed before your lordships, to continue up to 31/12/25 shall continue to hold their post till such date of completions of the process. I am representing those untainted teachers. So now we can continue up to that. Well, on the very same day, another order was also passed. Lordship may kindly remember in one of the non-teaching matter, relying on a teaching matter of Orunima. Orunima was a teaching matter. Lordships, in an interim measure, also allowed that in a contingent way, allowed the concessions, age relaxations for those non-teaching sector. While Lordship passed that order, Lordship relied on Orunima judgment. Now, School Service Commission, my lord, they took it up before the Honorable Supreme Court. There one point that I think this is my duty to my lord. Huh? Correct. This is I must clarify one thing, that this matter, my lord, did not arise from the teaching matters. It arose from the non-teaching, but the reason I am showing it, that Lordship's interim order was relying on the Orunima, so effectively principal. So there, my lord, if I can just my lord, place it, having heard the learned senior counsel appearing for the petitioner commission, the senior counsel appearing for the state of West Bengal, and the learned senior counsel appearing on caveat advance notice such and such for the writ petitioners before the High Court, we are of the opinion that it would be appropriate for the High Court, which is still seized of the matter, to hear the parties concerned on all aspects after inviting necessary counter affidavits and rejoinders thereto, if any. Without undertaking this inclusive exercise, it would not be proper for the High Court to pass an interim order summarily that would have far-reaching consequences. We accordingly direct the interim order passed by the High Court on such and such date to be kept in abeyance till the matter is heard fully by the High Court and a final order is passed, be it in the interlocutory applications or the writ petition itself. The High Court would be at liberty to fix time frames for completion of pleadings and proceed in the matter thereafter. My only purpose of placing this before your lordship is this, that though I do acknowledge that this is not an order directly from the teaching matter, but taking the principle, and since all the matters were taken up by the Honorable Supreme Court and your lordships also relied on either way for the principal purpose, possibly what the Honorable Supreme Court indicated that these matters have to be decided finally. Because lordship may kindly remember that since we were getting our salary, because the Honorable Supreme Court somehow, my lords, unlike the non-teaching, took care of our survival. Now, in various matters, my lord, some interim order was sought for variety of interpretations, not only on one ground. For an example, one ground was that this is not in this matter, in some other matters, that if someone is appointed based on paragraph 31 of the Honorable Supreme Court, then it is after expiry of the panel, then he is also untainted. So my respectful submission before your lordship is this, that we are continuing on the basis of the Honorable Supreme Court's order based on untainted, they are to continue up to 31st December. Thereafter taken note of, still we can continue up to that. I am not at all saying that lordships would not decide who is tainted or who is not untainted. All I am praying is that possibly, if lordship feels so, that lordship would decide that part in a finality. Because in the midst of that, I was trying to understand this way, in the midst of that, kindly visualize that we are getting the salary, we are putting our service. Two interpretations are there. Now, one interpretation which petitioners think that that is the correct interpretation is that regardless of what is the tainted list.
No, it will be decided finally
Finally.
by interim order.
Yes,
It's all right.
Yes, because well, if I can just say only one sentence, because our only fear was this, there are number of matters. Like we are protected, for an example, there are 10 matters. But in one matter, one judgment, but that can also have a serious affectations. But I don't need to say that. All I say that either way, lordship will decide, it should be finality of it. But as far as the whether panel expiry, after expiry of the panel, they should be tainted or not. Though I made some submissions on the other day, but essentially there is a separate matter for this purpose. Lordship may kindly remember that there was one order initially lordship passed, thereafter lordships did not pass that order. So I'm not making my entire submissions on that. I will
Reserve it for that other matter.
For that matter, because this matter, my lord, I want to put a barrier in a sense that, take it as my submissions, that challenging of the rules, 10 marks, weightage part, my entire endeavor before your lordship is that this is constitutionally valid and this is proper. And today there is no fog. There is a sunlight and it clearly shows that there is a fair chance. But that chance was for the more intelligent, more meritorious persons.
All right.
Well, this would be my last submission. One intra point was taken, like those who had the experiences 9-10. Now, whether they
That
would
experience can be counted for
11,
11,
12. So that's so if Lordship take it from a legal perspective, rule requires an experience in secondary level. Whether the secondary level includes 11, 12 or not. Some submissions were made that it is not. So to respond, I will just show two things. Number one is the very definition though. Copy that. Now, kindly take the West Bengal Board of Secondary Education Act 1963. Lordship may kindly come the third page. The definition of secondary education. F. The second, Lordship has got. By saying third, I have not, this is actually in SCC online, it is page number 5. But from physical.
Yes, it's
that-
page number 5.
Yes.
L, secondary education.
Sorry, it is L.
Right.
Sorry.
Hmm.
So that is, I just saw it as F. Secondary education means general education above the primary education stage, provided for students with a view to qualifying them for admission to a certificate, to a certificate, diploma or degree course instituted by a university or by government or by a statutory body, and include subject to any general or special order of the state government. One, technical education, agriculture education, commercial education, education for the physically handicapped, education for the mentally retarded and defective, education in reformatory schools and jails, or 7, any other types of education which the state government may in consultation with the board. So my respectful submission is on the word above. So anything above primary, which takes them to diploma, university level and all others, that comes under secondary. So it is a wider variety. And the same, my lord, that is absolutely in sync with the national education policy. That also says so. Lordship may kindly take the National Education Policy 2020 at page 11. National Education Policy 2020, relevant paragraph is 4.1.
Yes.
Well, I shall be mainly relying on the last two sentences, but it's a short paragraph. I'm reading entirety. 4.1, the curricular and pedagogical structure of school education will be reconfigured to make it responsive and relevant to the development needs and interest of learners at different stages of their development, corresponding to the age ranges 3 to 8, 8 to 11, 11 to 14, and 14 to 18 years. 14 to 18 years covers respectively. The curricular and pedagogical structure and the curricular framework for school education will therefore be guided by a 5+3+3+4 design, consisting of the foundational stage in two parts, that is 3 years of Anganwadi preschool plus 2 years in primary school in grades 1 to 2, both together covering ages 3 to 8. Preparatory stage, grades 3 to 5 covering age 8 to 11. Middle stage, grades 6 to 8 covering ages 11 to 14. And secondary stage, grades 9 to 12 in two phases, that is 9 to 10 and in the first, and 11 and 12 in the second, covering ages 14 to 18. So my respectful submission is that this referring to the secondary experience possibly the rule maker never wanted a mathematical precisions of a particular subject taught in the 11-12. All they wanted that they should not have the experience of the primary, they should have the experience of the secondary, meaning thereby above what is there in the statute itself. So that's the reason. And if your lordships look at the leaving aside the law point also, if lordship look at from otherwise, that any experience, teaching experience, unless there is so sharply different. For an example, someone is teaching, if I can say mathematics, he may not have any experience in maybe completely a different subject. But overall, if a question comes whether he has a teaching experience in a secondary or not, and whether for which he would get the benefit, my respectful submission would be, my lord, the rule as a matter of policy, having chosen not to make a differentiation, taking a clue from the 63 Act itself, the definition of the secondary educations, which is also in sync with this education's policy, which is up to 14 to 18 years, it is valid and it is not violative of any of the constitutional provisions. Well, these are my respectful, sir. I only seek leave at the end, my lord. I shall give a short reply.
Can reply by the applicant, by the added respondents.
Yeah, no, I missed it. What your lordships?
Reply by the respondents. Reply by the respondents.
By
It will be done.
submissions.
No, you said at the end you'll make further submission.
No, not submissions. I said at the end, when the
Yes.
entirety concluded,
Written
if
note.
lordship allows me, I can give a very short 2-3 pages note.
Note.
It's
All
nothing.
right.
I don't want anything else. I was sitting what is saying? Which matter? 33 names of the addition of added respondent. Okay. Well, there is only one, though I am representing all, but there are some who stand even a better footing. Well, there is one paragraph in the main judgment of the Honorable Supreme Court that who had an earlier service. Like there is one applications wherein some persons had an earlier service. So that's an application in item 33. Item number 33. ওটা কি allow হয়ে গেছে? That has also been allowed. So only they seek that if because this point because they were apprehensive because of that definitions of the tent. Because of the several.
Then those who were
So now
in
that
earlier
is-
service, they have been permitted to be repatriated.
Well, they should be permitted. They should be permitted.
So that is a different thing.
No.
Are they again participating in second SLST?
Well, many of them are also participating. Many of them
Alright.
also participating. But they are parties because they are only apprehensions at that. Because today I don't think there is any apprehensions in courts of hearing.
Yes.
It can only be whatever the judgment will come.
After the judgment.
Yes, because they were
What are
apprehensive.
they apprehending?
Their apprehension was that as an interim measure, if lordship decides that anyone in 16 appointed after third counseling, they are also be treated as a
Tainted candidate.
then what will happen? Neither they would be able to go back. If it will, so that's the reason.
So this is a risk which these teachers are taking. You never know what the judgments will be.
Correct.
Right? And they are already recommended.
Yes.
I do not know.
But they can
then
go back. May I?
Can go back.
Yeah, they can go back. Yes. May I? Because this matter will continue. May I take specific instructions?
So take instruction, no issues with that.
And then I will accordingly. I will.
Yes.
Well, these are my respectful submissions. Deeply obliged.
Yes, who would like to argue next?
Item 33. I am the added respondent in can 6, my lord. Can 6, item 33. Enter bar করে দিন।
What is your status?
Well, we are the untainted teachers still continuing in the service pursuant to the order of the Honorable Supreme Court. 20
Correct.
teachers
20.
come before your lordship.
Untainted means what?
2016 appointed
Huh?
untainted teachers.
What does untainted over here mean?
Well, here, my lord, according to the Honorable Supreme Court order, we are continuing our job.
And
till
that is different.
different.
What untainted in the sense you were neither found to be rank jumped, you were not in the list, and you were not even appointed after expiry of the panel.
No,
No.
third counseling.
Third counseling was done after the expiry of the panel.
Well, that is my lord. Another matter is pending, my lord. That is another thing, my lord. After whether they our fault or there are some reason, my lord. For that reason, my lord, the delay was.
No,
done for
that
the,
argument has been elaborately made that the
that
candidates
matter
who
not
have
today,
been
my lord. That
is
matter.
continuing. Candidates who were appointed beyond the cutoff date of the panel, expiry of the panel, they should not be taken to be as specifically tainted candidates. This is the argument that is going on. Which category do you fall?
My lord, that 20 teachers are, my lord, are continuing their job pursuant to the order of the Honorable Supreme Court.
Listen, try to understand.
Yes, I understand, my lord.
What do you
That is, my
understand?
lord, my lord, disputed question of fact that matter is already pending before your lordship, whether we are within the zone of untainted or not.
Right.
That is another matter, my lord. But here, my lord, item 33, probably, my lord, that question or that after expiry of the panel, those candidates, those teachers have appointed, whether they are untainted or not, that is consideration before your lordship in another matter, my lord.
Yes.
But here,
Hmm.
that 20 teachers have come before your lordship, my lord. We file, my lord, affidavit in opposition. Kindly have a look into my affidavit in opposition.
What is your stand, you tell?
My lord, my stand already now, my lord, from my learned senior friend, I came to learn that already freshers in respect of 9-10, 68.89%. And my lord, 11-12, 49.4%. So, my lord, those teachers, untainted teachers appointed in the 2016, they already left the field. Most, my lord, according to my lord, information, 1,500 teachers.
Left the field, what does
They
this
left,
mean?
my lord, in the competition. And
They were not successful.
no, not. Because of the 2025 rules.
Hmm.
Because of the new rules, along with fresher candidate.
Hmm.
That's, my lord, the ambit of the judgment of the 3rd April passed by the Honorable Supreme Court in paragraph 49, nowhere it is stated that SSC, West Bengal Secondary Board, SSC will frame the rule and we have to compete with the fresher candidate.
So you are also challenging the rule.
No, my lord, here we have addition of party, my lord. My lord, my lord, contention before your lordship that due to this rule, we are affected.
That means you are challenging the rule.
But in the addition of party, we cannot challenge that rule. But our contention before your lordship that on 3rd April 2025 order and 26 November 2025 order. Kindly have a look into 26 November 2025
Listen,
order.
try to make things
Our
clear.
interests have been affected.
So you file a fresh writ petition. Why do you add
that
yourself?
petition is pending before your lordship and that is fixed on 12.
Are you a party over there also?
They are also, but the writ petition are filed, some of the writ petition are filed, but that writ petition challenging the 2025 rule, they are the untainted teachers. That was admitted by your lordship and directed for opposition.
Here, the applicants whom you are representing, did they file any application in that matter where the tainted list has been challenged?
Matlab, 2025 rules challenged by other untainted teacher, not
You-
these petitioners.
Not you.
No, my lord.
So, what grievance do you have over here?
Here, my lord, the applicant's contention before your lordship, 3rd April 2025, 2025 order, that, my lord, here post has been decreased. Some of the post has been vanished, my lord.
Sir, you are getting it wrong. The petitioner is challenging the rule. You are also challenging the rule. Right? Why don't you come up with a fresh petition?
Well, that petition is pending.
By some other party.
Some other person.
Very well, whatever will happen will cover you.
But here, my lord, kindly have a look into kindly have a look into my petition, my lord.
What is
Addition
your
of party.
grievance? Your grievance is challenging the rule.
Matlab, challenging the rule or 10 months experience.
That
10
is
months
all in
experience,
the rule.
we are not benefited.
That means you are challenging it.
But challenging
Things
that
clear.
is true. But 10 marks, my lord, additional marks not benefited us. My lord, now it is clear and crystal that marks not benefited us. That 10 marks experience not benefited us.
So
We
you are
already
not
left out.
sure whether you challenge the rule or you do not challenge. You participate. You are entitled to the 10 marks. Even then you fail to qualify and now you change your stance.
Because, my lord, I am not changing our stance, my lord. Because of the fact, my lord, along with fresher candidate, we did not compete. Because of the but that is not the contention of the Honorable Supreme Court on 3rd April.
File a fresh composite petition and let us see or wait for what happens to the other petition where the matter is pending. You do not have any grievance over here.
My lord, kindly have a look into my petition. 1 second, my lord.
You say whatever is there.
My lord, here the 20 candidates have got the marks, my lord, in the written examination. My lord, page 11, Roman 10, my lord. Page 11, my lord, out of 60, 47. Out of 45, 40, 48, they got the written examination. Got the marks in the written examination. In spite of that, my lord, now, my lord, they left the field because of the, my lord, the marks awarded for only postgraduate and graduate level, not for, my lord, Madhyamik examination, higher secondary examination.
Sir,
and not only that,
come up with a fresh petition with all your allegations and whatever grievances you have. In the petitioner's
starting, my
petition,
lord, 2611, kindly come to 1 second, my lord, 2611 order, my lord. Your lordship, kindly, 1 line. My lord, High Court shall also be mindful of the fact that the untainted candidates in the past election were allowed to sit. I am not on that. And their candidature cannot be adversely affected by application of the new rule. Our candidature already been affected because of the new rule.
try to
Already some
understand
post-
one thing.
My
This
lord.
is not an open forum where you can go on making submissions. There is a petition before the court. Either you say yes or you say no. If you have something else to say, come up with fresh petitions. Here, you cannot. What is the can? Can number? 6.
Can-
Please come. Take one order, please.
Can 6.
In item 33.
I think, my lord, yes, Bhim Kumar Sarkar.
Bhim Kumar Shah, please come. And order record করুন তো. Can has been allowed. Can has been allowed earlier.
Earlier allowed.
Right? Take down item number 33, 24899, 2025. The applicants in Can 6 of 2025, 6 of 2025 in connection with 24899/2025. Challenges the act of the commission and the state respondents in publishing and framing a new rule for conducting the examination for recruitment of assistant teachers. Stop. It has been submitted that the same is contrary to the judgment passed by the Honorable Supreme Court on 3rd April 2025 in the matter of Boishaki Bhattacharya cost title লিখে দেবেন ঠিক আছে
26.
Paragraph
2611.
The application of the petitioner for addition of party was initially allowed, but after hearing the applicants, it appears that the cause of action which the applicants are espousing cannot be decided in the instant writ petition at the instance of the applicants. Stop. It will be open for the applicants to file fresh writ petition challenging the action of the authorities if so advised. Stop. Can accordingly stands dismissed.
Obliged, your lords.
In
কেন
cannot treated to be days list করে কথা আরে ওটা তো অ্যালাউ হয়ে গিয়েছিল
এখানটা তো আগে
Yes, next submission by
Item 37, my lord, for Can 4, your lordship had already added us. My lord, we have filed an affidavit in opposition. Last occasion, it has been recorded also, my lord. My lord, this is that matter, my lord, where the petitioners says that candidates of 9-10 will not get the marks of teaching experience since they have.
please make submissions. Yes. Because just now this point has been addressed.
Yes.
Make submission.
Well, only one thing, my lord. We have filed an opposition. That's why I have stated, my lord. My lord, Mr. Shandal is leading me. My lord, he's coming. My lord, just 10 minutes. Can it be passed over for 10 minutes only?
All right. Anybody else who wants to make submission? Applicants?
Item number 32.
Yes.
Can 5. I'm one of the
Right.
applicants. I'm being led by Amrita Chatterjee in this matter. He's on his legs, man. He's on his legs.
Somebody should be here. See, the senior can always be on his legs, but somebody should be there to at least carry the matter forward and so that the senior steps in.
Just
not there. Item 32, there were many applications, if I can remember correctly.
I'm from Can 5.
And 5, there means there were 1, 2,
Three,
and then
4.
3, 4, and then 6 also. Anybody for the applicants in these matters? Because prior to starting with the state and the commission, I would like to finish off with y'all. Why don't you start so that Mr. Sanyal can come and take it up?
Ishojit Vishwast.
In which matter?
Well, item 37.
57. Vishwajit Vishwas. All right.
Opposition copy to the.
Are you a job loser also? Because
Yes.
you were there.
We are teachers of
And-
class 9 and till 9 and 10, my lord. My lord, we have our contention is that, but award of 10 marks for teaching experience should be awarded to all, irrespective of their classes, whether it is 9, 10 or 11, 12. My lord, here the contention of the petitioner is that the award of 10 marks should not be awarded to teachers of 9 and 10 since they are not taking classes of classes 11 and 12.
No, you are not clear. Frame it differently. You are not clear. You are not really. I can understand.
10 minutes, kindly allow me
I
10
can
minutes.
understand. Yes, you.
Ma'am.
Yes, right.
Well, I have the
Reply.
reply.
আমি reply copy পাইনি।
Which matter?
This matter 37.
37. Yes.
I filed
Your
reply.
allegation is that
Malad ki-
experience of 9, 10 cannot be considered in 11, 12. Yes, place it.
We have not received the reply.
All right, he'll serve. Yes.
Well, kindly in paragraph 6, my lord, in my reply.
All right, paragraph 6.
That Malad, with reference to the statement made in the paragraph such and such, Malad, I deny and dispute it state that 2025 recruitment rule, the teaching experience marks are categorically segregated and mentioned separately for recruitment to the post of the assistant teacher in 9, 10 and 11, 12 classes as because the selection process, the academic qualification are different and written test was held differently. For that reason, the marks of the teaching experience for the post of assistant teacher in 9, 10 and 11, 12 class are mentioned separately in the said notification. But the School Service Commission, by violating the aforesaid circular, granting the marks of the teaching experience for the 9, 10 in school, for the post of 11, 12 classes, this classes teacher recruitment, which is not maintained with the eye of law. Second, my lord,
No, I could
The-
not follow. I could not follow this.
but there is the two separate
একটু
recruitment
দেখি
process.
ফাইলটা একটু দিন না আইটেম 37 ইয়েস রিট পিটিশনটা প্লেস দ্য রুল
Page, my lord, 74. Page 74, my lord.
74
Yes.
হ্যাঁ থাকুক ইয়েস
Schedule 2. My lord, kindly see, my lord, two separate, my lord, the procedure for, my lord, the marks is also, my lord, the difference and teaching experience, my lord, written categorically different. So, my lord, there is the two posts, one is for the 9, 10, 11, 12, and another is the, my lord, the 9, 10 and 11, 12. Two separate selection process. There is the qualification is the different and written test also difference. For that reason, malad the two, the teaching experience, malad the written separately. So, malad they have no teaching experience in the 11, 12. So, their marks for the teaching experience given for the post of the 9, 10 for the 11, 12, that is one of the contrary of the law. Because one of the 9, 10 teachers have no teaching experience in the 11, 12 class. Now, that's why one of these marks would be given for the particularly teaching experience for 9, 10 for the 9, 10 teachers and 11, 12 for the 11, 12. That is one of the contention and the rule has been framed for differently and one of the teaching experience marks has been given differently. So,
so see schedule 2 first is for 9 and 10
yes,
prior teaching experience 10 marks at the secondary level
yes.
and in 11 and 12 also prior
B.
teaching experience is 10 marks
Yes.
at the secondary level.
Yes.
So it is the same thing.
No, this is one of the two different posts and one of the qualification
is
is the different. Qualification is different. And the well-settled principle of law, they are one of the working in the lower post, their teaching experience cannot be treated for the higher post.
Where is that?
Well, kindly the judgment. So, well, I am placing all of the
What is the qualification for 9, 10?
9, 10, my lord, they have some there's some candidates who are working in the 9-10, during the service period, they enhance the qualification and subsequently thereafter they applied for the 11-12. They are putting their experience for the 11-12. That is illegal. That is not permissible under the law. Because I have posting, I have holding the as a PG teacher with the graduation and B.Ed, and thereafter subsequently I working for the 5 years or 10 years in the 9-10 school, and subsequently I enhance my qualification and I apply for the 11-12. I have giving the marks, teaching experience marks for the 9-10. That is not permissible because teaching the identity code is the one.
1 minute. The educational qualification required for appointment in 9-10 and 11-12 is the same. See page 73.
Pay scale is the difference.
Pay scale is different.
Is different.
Different
The
thing.
selection process is different. Post is the different. There is the below post. The 9-10 and the 11-12 not the similar categories. There is their post. That's why it is segregated because they are working for the higher category. They have already they have teaching experience and they applied for the teaching experience in the for the 9-10 school and they are taking the double benefit in the for 9-10 school once and the 11-12. They are the teaching experience. They are the code of the teachers is the one, and they are they have all they have to be granted the teaching experience for marks for the one category. They have taken the double benefit for the 9-10 school one for the same category and then the 11-12. That is one of the rules. That's why the rule has been prepared. The rule has been categorically stated for the subject that post in which post they has been working. Suppose one candidate the enhanced qualification in another subject, they apply for the 11-12, they are not entitled to get the marks teaching experience for the 9-10 school. That is the contention before Lordship because this is the in that case, what happened? All the untainted teachers who are applied for the 11-12, they are not getting the chances because the 9-10 school untainted teacher, they applied for the both posts and were they getting the marks for the 9-10 and 11-12, they have been double benefited.
How can there be double benefit?
Because they have taking the marks for the 9-10 school once and 11-12. One for the one teaching experience, they are getting the 2 marks for the 9-10 and 11-12.
Selection process. Selection process is different.
Selection process is
It is not
different.
that 10 plus 10, 20 marks they are getting.
No, that is they have
Then?
given the double benefit because the 9-10 school is the different.
Yes, that
The post
they
is
have
different.
their experience, whether they teach in 9-10 or in 11-12.
Yes.
Wherever they compete, they use this experience.
Use experience for that post only because for 11-12 they have no teaching experience. They have experience in on the 9-10 school in particular subject, but in the 11-12 they have no teaching experience. So the putting question on myself, they have working for
You show it by backup by judgments or anything.
But another point is the paragraph 7 also. When I am placing the judgment. Paragraph 7 is the lower post working experience not taken into consideration for the higher post. And kindly see the page 6 of this my opposition.
Yes.
Well, last portion, we kindly see page 6 in paragraph 8. This also stated that those who are working in the teaching in 9-10 school and subsequently thereafter they enhance their qualification in other subject, they have also applied in the post of assistant teacher in 9-10 school and they are also included in the call for verification list by putting their teaching experience in 9-10 school
in other subject. As a result, those who are appointed with the higher qualification in 11-12 school, they are deprived of getting chance to appear in the interview for the post of assistant teacher in 11-12 school, though they have teaching experience in 11-12. Malavans. For 2022, SCC Online Kerala 7024.
Here your status is a job loser or what?
Job loser.
You are a job loser and you are contesting for 11 and
11,
12.
But what happened, my lord, due to, my lord, the untainted teacher of 19 school, they applied for the, my lord, the 11-12 school. My lord, for that reason, my lord, the others, those working for the 11-12 school, not getting the chance.
Why did you not apply for 9 and 10? Was there any particular reason?
No, because we are the holding the higher post. That's why, my lord, I have applied for the 11-12.
Yes.
Paragraph 14, 15 and 16. One of the prepositions they teach, the teaching experience should take into consideration with the the requisite qualification when she is working in that post. Paragraph 7, my lord, kindly see. My lord, kindly see page para 4, my lord. They give him the discrimination, my lord, their appointment and teaching
1
experience.
minute. This is in the matter of Dr. Asha Sridhar.
Yes, yes.
Paragraph 4.
4 is the, my lord, tabulation sheet.
Yes.
Their date of appointment and experience and everything. Considering this, my lord, paragraph 7.
Paragraph 7. Yes.
It can be seen from the table above, the Dr. Padmaja Devi and Dr. Asarada obtained their PG qualification only in 2005 and April 2006, respectively. After they are also promoted in reader, assistant professor, Dr.
Whatever.
Yes.
On the other
On the other hand, and obtain her the PG qualification even by the time of her initial appointment as a tutor. It was therefore her case before the tribunal that although it has been fact that Dr. Padmaja Devi and Dr. Asha Sridhar adopted their PG qualification with the extended period granted under the special rules of force, the period spent by them in the various posts where PG qualified was prescribed as the essential qualification could not be counted towards the teaching experience required for the post of professor, where also the PG degree was prescribed as essential qualification. She also relied on the provision of the such and such. This is the contention, Maladi, that time when the dictionary is working in that post, there is the qualification and higher qualification that experience would be calculated for the post of the higher post when is the promoted. In this case, those the teachers is working in the.
What is the judgment? This is the contention.
Contention, and this is the last portion, my lord, kindly see, page paragraph 10.
Yes.
Pre-contra argument.
That is the
yes,
submission.
Yes,
What is the
submission.
finding
And
of the court?
kindly see. Paragraph 16, my lord.
Yes.
In my view of the matter, we find that the argument of the Learned Student Council of the petitioner before us in view of the exception and relaxation granted to them for the obtaining the essential qualification PG, they should be seen having gained in the acquired teaching qualification of the PG teacher in the various posts, and they had occupied cannot be illegally counted. We related that the teaching experience prescribed under the PESA rules has to be read along with the provision of the 10AB of the part of the such and such, and the light of that center regulation holding the field, and when so did the teaching experience can only be one that is qualified after the acquisition of the essential qualification required to be the post of the professor. We see no reason to interfere with the impugned order of the tribunal, and for that reason, the supplement and the reason, the judgment, and this is to be one of the
How does it fit in your case?
because Manoj, I have one of the holding those one of the working in the 11-12 without the qualification to apply for the 11-12 school, that experience cannot be taken into consideration for the post of 11-12 because
How does the facts of this case fit in your case?
because Manoj, these persons who applied for the promotional, when the working with the higher qualification, that experience should be calculated for the higher post. Because other two candidates, they obtain their qualification after that, that time experience cannot be taken into consideration. This is the contention and proposition.
What you are submitting is something too very general. See, somebody applies for 9 and 10 working. He or she enhances the qualification later on and then
Applied for the 11-12.
11-12.
By putting the experience,
Right.
when that time there is no qualification. That
Qualification.
is.
Right. Now,
So Maharaj, somebody have the with qualification and somebodies are without the qualification for the higher post. That will not be segregated in just in this way. But that's why the rule has been framed. And Maharaj, the two categories of the classes of the teacher, 19 and 11-12, for that reason, but two separate but the teaching experience marks has been given. Because if the common things, then Maharaj, the only one clause is there. All our teachers will entitled to get the marks for the 10 for their teaching experience. There is no necessity, my lord, to putting question of myself.
suppose somebody doesn't have the qualification of teaching candidate in 11-12. Somebody doesn't have. He only has the qualification for teaching in the secondary level because that is what the rule says, secondary. That person is also eligible for 10 marks for being appointed in 11-12 category. What is your submission?
My submission is for the, suppose for the secondary. There is no specific rule for the 11-12 and the 9-10. All are secondary. Even in upper primary school, but there is also included in the secondary level. For upper primary school, there is no such rule for the others. They all are secondary levels. So in that case, upper primary teachers not taken into consideration for the teaching experience. If we are all in the one cloud of secondary, so the upper primary teachers should be granted the marks for the 10th. That is not. But that's why segregated 11-12 teachers should be entitled the marks for their teaching experience, and the 9-10 they are separate the marks for their teaching experience. But that's why the rule has been framed. And subsequently, what happened? The School Service Commission initially decided, this is my thinking, that is segregated and rule has been framed in different way. This qualification, teaching experience, everything is different for the 9-10 school and the 11-12 in differently, and they have framed the rule and two way because there is the two categories and the experience marks also given separately. If in open to all giving the marks for the teaching experience, there is one clause. the all other teachers will entitled to grades for the teaching marks for 10 marks. What is the necessity, my lord, the putting question of myself to separate category and to separate teaching experience. So that is intention is that the 11-12 teacher will not get the marks for the, my lord, the 9-10 school, and 9-10 teachers will not get teaching experience marks for the 11-12. Even, my lord, one thing is that in the application form, one is the, my lord, the teachers the one code. So one code, one teaching experience has been allotted. But subsequently, school service commissions changed their view. They're giving the marks to 11, 9, 10 school teacher for the 19 school and 11, 12 school. But that is what is the necessity of the making the rule for in defined two categories. There is no necessity because each and every person who applied for the post, they will get the marks for the 10 marks. That is not. That's why they frame the rule separately and they indicated separately in the teaching experience. So this is highly illegal in 9-10 teachers. Those have no teaching experience and no have qualification for the appointment in the at the time of their working, they have applied for the 11-12 school. And my learned friends, another contention is that they are the examiner of the 11-12. And for that reason, they're claiming for the experience marks for the 11-12 school.
Only examiners.
But they have putting their in the application for additional party. They have work also the 11-12 school, some works. For that is they deserve the marks of the teaching experience for 11-12.
That means it not teaching work.
Teaching works, this is the some extra work. We are working for the 9-10 school. I have also look after the examiner of the 11-12 students. That's why I'm not claiming for this is the judgment.
I did not follow. I did not follow.
The one those have the teacher of the 9-10 schools. They the examiner of the 11-12.
Examiner means what? He looks after, he checks the answer scripts in examinations. 9-10 teachers.
Yes.
Checks answer scripts.
Yes, that is they let them state has been they have given the papers to checking for the
if they check papers, that means they have that qualification to check it. Otherwise, how
no,
check?
it is not. That is there is the judgment of the 1991 supplementary to SCC 733. If I have holding the lower post and I have looked after the upper post and doing the work, I am not deserved for the entitled to promotion for showing I have the experience of the that.
This is not a matter of promotion.
But this is the related to experience and the qualification.
Whether the experience of 9 and 10 can be counted.
Yes, yes. I have stated, make my submission because they separately they have framed the rule, and there is the to separately they have given the teaching experience. The rule itself, the displayed that there is the two category of the selection process, two category of the the post, and pay scale is the defined. So, the lower post holder cannot claim for appointment by showing their teaching experience for the 11-12 school.
Yes.
But another judgment is the 1991 supplementary to SCC 733.
देखिए जजमेंट है yes
Paragraph 5, my lord.
paragraph 5
Paragraph 5 onward.
all right
The argument in contemplation of the order plainly do not amount to a promotion of the appellant to the post of the lecturer, treasurer. The distinction between the situation where the government servant to promoted to the higher post and one where he is the merely asked to discharge the duties of the higher post is too clear to inquire and any reasonably asking and the officer who subsequently hold a lower post merely to discharge the duty of the higher post cannot be treated as the promotion. In such a case, he did not get the salary of the higher post, but gets only that the service parcel in the call to change allowance. Such situations are the template where the exigency of the public service necessities and arrangement and even consideration of the scenario do not enter into the the contention to hold that the substantial lower post only discharge the duties of the higher post essentially is to be the stopgap arrangement. And last one, paragraph 7, the second contention is that the definition of the expression absorbs post and absorption employee in section 2 of the act is wide enough to take into their sweep not only a person holding the absorbed post in before December 20, 1961, but also one who has merely serving in the higher post and that accordingly such higher post also render in relation to the persons as absorbed post, we afraid this construction is clearly unsupportable. And paragraph 9, my lord. The third contention is the appellant in charge arrangement in the higher post had contended for so long a period that determination of the equivalence on the basis of the lower substantial post would become arbitrary. This contention ignores the fact that in charge agreement is not the recognition of is necessarily based on the seniority and therefore no rights, equities and exceptions should be built upon. The third contention is that the unmeritorious.
so this was a stopgap arrangement somebody
Yes,
was
that is
working.
they have given the work, they working, so they cannot claim they have working for that post, that is I have the acquit the right to promote in that post. So in this wise they are giving they are taking the examination from the 9-10 school, 11-12. So that's why I have the
Experience
their
of-
rights. Yes, yes, that is the contents. So, my lord, as per recruitment rules, as well as my lord, as per experience, they cannot claim for my lord, teaching experience for the 11-12 school. Suppose one candidate, my lord, working for the some subjects, the NS qualification and other subjects, they apply for the 11-12 school for showing that subject, but taking into the my lord, experience in the 9-10, that is not permissible under the law.
yes
So, in my reply, I have stated, in paragraph, I have already the submission before Lordship on paragraph 6, 7, and 8 by considering the Yes, kindly not allowed to, my lord, 9-10 teacher to participate in the, with the marks of the teaching experience of 11-12.
See, there are many cases which I have got where postgraduate degree is there, the teacher is qualified for being appointed in classes 11 and 12, but then the teacher is actually appointed in the lower classes, say 9 and 10. Due to vacancy in 11, 12, these teachers are directed to work in the 11, 12 section and they regularly teach there. Can their experience not be counted?
But one
Though
is-
their regular appointment is in 9 and 10. Their appointment is not there in 11 and 12. But they are regularly taking classes of 11 and 12 because they have got their qualification. For the sake of the students, they are doing it.
my lord, they have taken the classes, but there is no, my lord, authenticity, there is no permission for taking the classes.
There,
Because
definitely there is
this-
permission. Otherwise, how can the
Otherwise,
teacher?
they get for, they have paid for them on a higher scale of pay.
No,
That is
no,
what the
those-
pay scale is the difference. So if I am working in the 19 school, I am taking classes for the 11, 12 with my qualification, so I can apply for the higher scale of scale.
Assuming somebody applies and gets the higher scale of pay,
Yes.
then
But there is no, my lord, the microscopic way to segregate it.
yes.
Because that is the point. My lord, if how can I segregate it? So those have the with qualification to, my lord, be applied for the 11, 12 school. And that is
So
for
what
that
is-
reason, my lord, for that reason, the rule has been prepared by category wise, the 9-10 differently and 11-12 differently. Even marks as teaching experience also have been given in different ones. So that's why they have framed the rule. But this rule has been prepared in continuation 2016. This is not the common recruitment process, probably as per order of the Supreme Court. This selection process is conducting. And also, the review petition, they have given the benefit to the untented teachers. The one thing is that, maximum untented teacher, in the 11-12 school, due to this point of my argument, they are not getting to chance to their recovery of their service, because due to maximum 11-12 schools in that in the working period of 6 years, they obtained the master degree and higher qualification, and they applied for the 11-12 school. So, without the qualification, if they working for 6 years, in the 6th year end, they have applied, they obtained the qualification in the master degree. Without the, they have getting the marks, 10 marks for the 10 years experience, but 6 years experience. That is impermissible, because that time they have no the qualification.
Yes.
That's
because of that separately
Great.
address, my lord. And senior friend, my lord, Mr. Dhar, my lord, addressed that the definition of secondary education is there, my lord, but I believe is not go through the definition of.
Yeah, you will reply. I'll hear Mr.
Before
Sanyal.
it will be kind of, because Mr. Sanal will give the reply, that will, my lord,
Give reply. He will
He-
place it. He is the applicant.
applicant, that means he wants the benefit, but which is not permissible. I just show it, then it will helpful for him to give the reply. Because of that, that secondary education definition is obviously is there. And there is also higher secondary education is also different. And that 9-10 qualification and 11-12 qualification is not the same. Kindly see the rule, my lord. Kindly take up the rule, my lord. And my lord is
25 rule.
yes, my lord, 25 rules.
না না বলতে বাধা দিস কেন বলুক সবাই বলুক
My lord, kindly see the schedule 1.
Hmm.
The 9-10 qualification, educational qualification. This column, schedule 1, got it? my lord?
Graduate, postgraduate.
Graduate oblique postgraduate. So any of the qualification is for the 9-10. Now, my lord, kindly take 11-12.
Postgraduate.
Only postgraduate.
Right.
So 11-12 category, a 9-10 category teacher never get the benefit of the 11-12 category. Why? Suppose a 9-10 category teacher, he have a graduate degree.
No, suppose the 9-10 teacher having postgraduate.
Postgraduate degree. In another way, my lord, I taking up. My lord, NCT says, my lord, because NCT segregate the class 1 to 5 primary, 6 to 8, that is upper primary, 9-10 is secondary, and 11-12 is the higher secondary. In the regulation 2014, my lord, in last occasion, my lord, I handed over, my lord, because this rule is also says that they will follow the NCT. NCT regulation 2014 is very specific for which category teacher got the benefit for which category. In our High Court, one of the division bench, I believe Mr. Shanal is also appeared in that matter. And that question arose first time in the primary matter. In the primary matter, some of the upper primary teacher, para teacher, they want benefit in the primary. Single bench allowed it. If I'm not subject to correction, if I'm not wrong, my lord, out of my memory, that West Bengal Board of Primary Education went to the division bench. Division bench says no. Upper primary para teacher not get the benefit of the primary. Although upper primary is the in higher pedestal, but they are not entitled. Why? Because of that, my lord, he might be take class in that category. That doesn't mean they get benefit of that class or that experience. Because of that, in the 2016 selection process, suppose because this rule is clubbing up all, but the earlier selection process, also this selection process is also the separate selection process is conducted. 9-10 separate selection process, 11-12 separate selection process, upper primary separate selection process, primary separate selection, even primary by the separate authority itself. Suppose if the benefit is given, the even a 11-12 teacher got benefit 9-10 or vice versa, then my lord, same question will arise in the case of upper primary. Same question will arise in the case of primary. Then every teacher is going to get benefit for everywhere, specifically who are in the higher pedestal. Suppose a primary selection process is going on. I just give an example. Secondary or higher secondary teacher, they take class of higher classes. So he might claim the benefit of the primary, but the primary benefit he will not entitled because he is not appointed in that particular post. And NCT also segregated that particular class, as well as in our state, there is an act, specific act, education manual. It will be kind enough, take the education manual. Act said volume 1.
Headmaster's manual?
No, my lord, education manual.
Education manual is not here.
This is the volume 1, my lord. I will show just, my lord, 3. One is that West Bengal Council of Higher Secondary Education Act 1975. And another one is West Bengal Council of Higher Secondary Education Admission and Allied Matter Regulation 2006. That is page number 812. That is West Bengal Council of Higher Secondary Education Act 1975. Section 2, subsection D.
Yes, higher secondary education.
Higher secondary education. Higher secondary education, except in relation to such class of student as the state government may specify in this behalf, means such education commencing after the terminal stage of school education. So it is specified school education in the pattern of secondary education. So it is after secondary education, introduced with effect from 1st day of January 1974, which concludes with the passing of the public examination, but by whatever name called and instituted by the West Bengal Board of Secondary Education, as is provided for students with a view to qualifying them for admission to diploma or degree course instituted by a university or by government or by statutory body, and includes subject to any general or special order of the state government education in humanities, science, commerce, agriculture, technical courses or other courses, vocational or otherwise, which the state government may, in consultation with the council, specify. That's why, my lord, will remember, we filed the get benefit of that vocational teacher, because in higher secondary education, vocational education is also included. That's why the vocational teacher wants the benefit of the 10 marks, my lord. But they not give it. In contrary, they gave the benefit to the secondary teacher in the higher secondary level. My lord, kindly take, my lord, West Bengal Council of Higher Secondary Education, Admission and Allied Matter, Regulation 2006. So, my lord, here, my lord, they specifically in this regulation, this admission in class 11 and 12, the whole regulation is important. For the saving of the time, my lord, where my lord specifically narrated what is the meaning of the higher secondary, how they will take admission. My lord, after this council act, my lord, my lord, after the council act, my lord, regulation 1976, thereafter regulation 2006, my lord, the examination regulation, thereafter admission regulation. And there is specific mentioning the admission in class 11 and admission in class 12, my lord. Specifically narrated. So higher secondary means classes 11 and 12. And kindly take that, my lord, that regulation 2014 of the NCT. NCT একটা bunch এর আগের দিন দিয়েছিলাম সেটা মানে last day, my lord, I remember, my lord, I handed over a bunch of NCT.
All right.
Petitioner ওটা additional point যেটা argument হয়নি স্যার বললো তোমরা অ্যান্সার দিবে, তোমরা তো আলটিমেট। ওই পয়েন্টটা তো বলেনি, ওই পয়েন্টটা তো লাস্ট ওকেশন no 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 Malar, last occasion, Malar, I handed over a bunch, Malar, where Malar, the NCT Act was there as well as the regulation.
Understand.
Just show, just one tabular chart is there, Malar,
All
where
right.
Malar, specific mention about the classes. What class means what. But kindly see that tabular chart. NCT বলে লেখা আছে। ওটা না NCT।
ওটা নয় ওটা নয়
এর আগের দিন দেখে দিচ্ছে পরে দেখে দিচ্ছে এর আগে।
Yes, NCT.
NCT Regulation 2014. Malar, here is the name of the regulation. This regulation may be called National Council for Teacher Education, within bracket determination of minimum qualification for person to be recruited as education teacher, physical education teacher in primary, 2014 regulation. That's 2014 regulation. Where, Malar, in the first schedule, Malar, that is mentioned, what is the meaning of preschool, primary school, pre-primary school, upper primary school, secondary school. entry 4. And here, my lord, the same qualification. In entry 4, minimum qualification is narrated, secondary stroke high school, within bracket for classes 9, 10, graduate stroke postgraduate, the same qualification, because they follow the NCT. In the rule itself, they mentioned that they follow the NCT minimum eligibility criteria, because they ought to follow. According to NCT Act 2011 amendment, because NCT earlier,
Yes.
NCT earlier was a dedicated institute for supervising the Teachers Training Institute. Thereafter, after coming to the Right to Education Act, there is a amendment in the NCT Act itself. And after amending the NCT Act, Section 12A, my lord, you remember the last occasion I referred it, Section 12A was introduced. And that, by virtue of that amendment, the NCT being an academic authority, because the NCT becomes the academic authority in pursuance of Section 23 of the Right to Education Act, because central government appoint NCT as an academic authority. Thereafter, NCT, for bringing the standardization of the school education, they floated this minimum eligibility criteria concept. Thereafter, NCT, first time in the year 2010, came up with a notification, the minimum eligibility criteria for the classes primary 1 to 5, there, as well as the 6 to 8 in the year 2010. Thereafter, 2011, there was an amendment. Thereafter, regulation 2014, the first time. The first time in the regulation 2014, they says the minimum eligibility criteria in the classes 9, 10 and 11, 12. That is in the high school level and secondary level and higher secondary level. So in the first time in the year 2014, they came up with this regulation with that minimum eligibility criteria. So after that, my lord, when they specifically denoted that higher secondary education, in the earlier selection process also, there was a dedicated selection process in secondary as well as the higher secondary. So if you give the benefit of higher pedestal teacher or higher classes teacher, then same benefit ought to given for the primary also. Who is the upper primary teacher, they also get benefit with the primary. Who are the say higher secondary teacher, get benefit the secondary. Even he also get benefit of the primary also, because he is the higher pedestal teacher. So my respectful submission in this regard is that, my lord, it is not that. Whosoever dedicatedly appointed for that particular class only get the benefit of that particular classes, otherwise not. If he want to participate, he might participate, but he not get experience number for that particular. And not only that, my lord, in higher secondary definition itself includes the vocational teacher. So that's why, my lord will remember, we were once benefited the vocational teachers also. They are entitled 10 marks benefit. That's why for the time being, my lord, after submission, my lord, my senior will reply.
বলে দিচ্ছে সবাই এখানে শিডিউল 2টার কথাই বলছি।
এই তো শিডিউল 2 স্যার রানিং পেজ 11 ও শিডিউল 2 ফলো করবে ডেফিনিশনে বলা আছে ডেফিনিশন বলা আছে এই তো এটা
Yes, Mr. Sanyal.
ওই জাজমেন্টটা নিয়ে ফেলবো। হ্যাঁ, তুমি পুরোটা
স্যার আমি ওদিকে চলে যাই
You are here in Bishwajit Biswas's matter?
Yes, ma'am. Can 4.
In Biswajit Biswas?
না না এটা বিশ্বজিৎ বিশ্বাস নিয়ে হচ্ছে
You want prior teaching experience marks for 9 and 10 to be given to 11 and 12.
But I'm appealing for both 9, 10, 11, 12. I'm asking for both.
স্যার আমি একটা কথা
Yes. 11, 12, you have worked, you've got experience, it's all right. But if you have not worked in the 11, 12 level, you have worked only in the 9 and 10 level, whether that marks can be awarded in the 11-12 stage or not? This is the question.
Malad, this question, according to me, itself against the rules.
Yes.
Your losses kindly.
That is the challenge to the rule.
Huh?
That is the challenge to the rule.
No challenge.
No challenge.
Kindly have a look at the prayer. I take your lordships.
I do not know in particular matter whether this is challenge or not, but the submission is that it cannot be.
That's your losses. Kindly, I'm ready to take your losses to that. Page 23.
Yes.
Prayer B. I will place before your lordships both the prayer B and C. To publish the notification by mentioning the special benefits which should be given to the untainted teachers in connection with the second state level selection test 2025 by considering the order dated 5th August 2005 passed in review petition being such and such. Then C, to grant the marks of the teaching experience in favor of the candidates, those have the teaching experience in the respective subjects and position in the same school where he or she was working and presently applied for, and also issue the notification mentioning the teachers of the 9 and 10 school are eligible to get the marks of teaching experience only for 9 and 10 school, and teachers of the 11 and 12 school are eligible to get the marks of the teaching experience for 11 and 12 schools. What they are praying for before your lawsuits, rewrite the recruitment notification. And then your lawsuits will find prayer D, to publish the notification by granting full marks for the lecture demonstration by considering that the petitioners are working as untainted teachers in connection with the state level selection test 2016, and further direct to publish the fresh notification by giving clarity that the lecture demonstration marks will be granted to untainted teachers, those who have acted in accordance to 16th. And then your lordships will be getting, kindly come to your lordships, F, certiorari, happily vague, delightfully vague. What they are questioning, Malab? So what today they are asking for, rewrite the notification. It's a basic principles of pleadings. But can they, Malab, ask? I'm concerned with that your lawsuits have enough jurisdiction to do anything, but not to do contrary to law. This is the prayer all they are arguing for all days. And now kindly have a look at paragraph 9 of the writ petition. This notification, rules, everything is published, your lordships. Kindly paragraph 9, page 14. That your petitioners state that the petitioners have made application for recruitment to the post of assistant teachers in SLST 2025 selection process. Admittedly, this was made. They have subjected themselves to the process, knowing full well this is the rules. Then they are now appearing, they say rewrite the entire process. This is according to me not permissible. Then they ought to have first questioned the rules. Prayed before your lordship, my submission, of course. That allow me to appear subject to this challenge. I could have understood that. That doesn't mean, my lord, I have a weak case. I have a very good case even on merit. That I will satisfy your lordships. Then your lordships, kindly take up the rules itself. I take your lordships the page. I just give you lordships.
What is your status?
My status, untainted teachers, I'm still working. But I have applied for both because I have the qualifications. Both. Your losses will astonish to see some of the cases that I'll be moving again, just out of the records. I applied for both earlier. In the 9 and 10, I got selected from the main merit list. I was working. I worked for 9 months. Then
2016.
Then I got, this is not the present one, but I'm giving a losses. Then I got a call letter for 11-12. In the fourth counseling, I appeared. But everybody wants better performance job. If I today give something, I will also go. I appeared, I got selected. Now everything lock, stock and barrel goes. Now the question comes up, how can I be said to be tainted, untainted? First of all, because I got selected in the first merit list in the 9-10. I was working for 8 months. Then I was called up by the council, board by council. The appear fourth council. I gave, went there, got selected, appointed. And now say everything bad. Now, another aspect to your lawsuits. I don't know, everybody probably will argue. Now, my lord, principle of wading out is being long followed by the Honorable Supreme Court also. This is also not in the present context. Now, your lawsuits had got the entire details. Who are rank jumped candidates, who are out of panel appointed candidates, and whose blank OMR seats or mismatch of worksheets. Had those candidates not been selected illegally, I would have been at the top.
All the submission will not.
Kindly wait, your loss is now open to all according to my submission. Your losses can take into that. Now, therefore, I have been suffering for somebody's wrong action, not for my fault.
Maybe the entire selection process.
That's one aspect. Therefore,
Everybody is
that is submission. This submission only confined to that I'm not tainted at any means. Now your losses can. Therefore, he applied for that selection process. Now your losses will find. Kindly look at the rules. It starts at page 64. This was rules was published on 29th May 2025. So everybody was put on notice that this will be the rules. Petitioners applied according to the rules. Selection process is governed by the rules. Now kindly have a look your lawsuits. Here your lawsuits will not find any definition of secondary level, higher secondary level. But I will deal with Mr. Samim's submissions in regard to that. Because everything should be determined on the basis of the rules when there is a codified law. Unless, my lord, somebody questions it and your lawsuit holds it, this is unconstitutional. That's a different. Unless this is done, everybody has to go by the rules. Now here your lawsuits will find, kindly come to Schedule 2. Page 74. Selection to the post of assistant teachers for classes 9 and 10 shall be made. This is for 9 and 10. But I will be precise. B, at the secondary level. It doesn't define. Secondary level doesn't define, my lord. I have worked, at least not upper primary up to class 8. So rule conceives according to me, as soon as upper primary ends, terminates at class 8, rest as secondary level. Clear to your lordships? Because I tell your lordships, their argument is self-defeating. Then if they construe it to only up to 10, then they will not be getting any marks either. Because kindly have a look at the next page. Prior teaching experience at the secondary level. Now, what if your losses read with this, with their prayer, they are trying to give your losses, rewrite the entire law.
No, their prayer may have been framed differently, but the submission is that 9-10 experience cannot be taken up for consideration in the 11-12 stage. This is the sum and substance of the argument. But the prayers does not appear to be framed properly.
Because they're conscious of it. Why they have made it? Because they're conscious about it. Unless there's a fresh notification, this cannot. Fresh law rather. Notifications means fresh law again. How could they ask for it? And now your lordships with this, can you look at page 31 side by side? Why I'm saying it, your lordships? Page 34, one of my application.
31 of your application.
Now, keeping it open, your losses. I'm
yours
requesting your losses.
Can
4.
এই মামলার can 4 টা একটু দিন তো। বাধা আছে না? ঠিক আছে। Yes,
ক্যানফোরটা দিন, অতগুলো মোটা দিন।
all tight. Page
Page
All right.
31.
31. Yes.
Now kindly see this. This is issued by the West Bengal Council of Higher Secondary Education. I was admittedly, my lord, working as 9-10 teachers. I'm taking their language because according to mission, appointment letter come meeting notice of examiner and scrutinizer. This is given not by the board but by the Higher Secondary Council. I am directed to appoint you both as examiner and scrutinizer for the subject mentioned above for higher secondary examination 2025. You are requested to read and follow the instructions, date of meeting with your head examiner, and the schedule of submission of marks in 2 installments as furnished below. I am also directed to draw your attention to the government notification of such and such of 2000, which has stipulated that evaluation is an essential duty of the teachers. But I'm putting a question to myself. Now, I am an admittedly a teacher of class 9 and 10. Now, I am being asked by the council itself, not by the recruiting agency, commission, do and examine the papers and be the scrutinizer. Somebody is our head examiners also. Now, here your losses, I give your losses, since your losses have experience from this side, both sides. Now it's open, my lord, I have all the qualifications, very good qualifications up to postgraduate levels. Your lordships have noticed by this time that everybody wants to pass graduate. Why, my lord? Because he had the knowledge much, but he wants to compete with the lesser qualified so that get the chance. This is for entry. Then higher scale comes your losses, lots of matters. Now suppose your losses, I have got a graduate grade teacher, but I have all the qualifications. I am being utilized like this. Does it not amount to teaching experience gathered by me? Now see, and kindly page 32, I am taking the classes even. That's why it has been kept open consciously by the subordinate legislature secondary level. That's my submission.
This is what I was just now mentioning, that there are many teachers in the 9 and 10 level who have got the postgraduate degree, but they are directed to perform or discharge duties of 11-12, but actually appointed in 9 and 10. Will they not get?
Exactly. Appointment may be subject specific to a class specific. But he had the qualification. Once you have entered into a school, you have to do whatever required for education. And that's why terms become secondary level. It benefits both of us. Then if the secondary level your losses they have to construe it, then entire selection process rules has to go. That's not the question. That's you cannot do it. And this is your losses, the higher secondary council is doing it. In all the matters your losses, most 99%. All secondary school teachers, if your losses, this is the restrictive meaning up to class 10, are taking classes of 11. Otherwise, no school will have. At least in our state. I don't know the other state. And I will take your lordships. Or somebody will jump up and say the central government policy has not followed, has not accepted by this government, but the rules say so. National policy of education says secondary level education means from class 9 to 12. But your lordships, I am conscious of that national education policy has not yet been implemented by the state. But the national policy is that. Because of the Schedule 2 under the Constitution, it's a state domain. State can. So this secondary level has been used, the language expression by the subordinate legislature consciously, so that's to extend benefit to both of them. I don't know why they are fighting with us. It's a merit position. Then may I conclude it? You are so intelligent, you can't teach the lower classes. That means the submission restricts to that. Then a doctorate candidate cannot teach class 9, 10. There are your losses, PhD holder teachers. Because they're so educated. They can't, your lordships, get the fathom of the mental intellectuality of a minor student, of young students, because they are for the higher classes. These submissions is not for your lordships, for the really for the honorable read courts. This is for the authorities to decide. They will decide. This doesn't harm anyone. It doesn't take away his right to be selected. Does it take away, my lord? He is entitled to. He is also getting.
The competition increases.
Malad,
We
that's-
will always want the competition to be less. Everybody wants.
Malad, what they wanting to restrict competition to themselves.
Obviously,
Now,
to the
that's not the
teachers,
law, probably.
the 9-10 teachers.
That's cannot be the law.
Not the 9-10, the 11-12 teachers.
This cannot be the law, my lord. Because the authority will use the teachers according to the need of the school, according to the need of the students. It cannot be restricted, and that's why the rule has been framed like this. My submissions, your lordships.
See, submission has also been made that a teacher is teaching appointed regular basis in the 9-10 section. The teacher enhances qualification in a different subject and then teaches 11-12. Goes for higher scale of pay and all these things, but regularly appointed in the 9-10 section. Will that teacher also be given the benefit of 11 and 12?
Not according to me.
Various.
Not according, I tell you, lordships, when I crossed the school, our all geography teachers were from commerce section, if not wrong.
Yes, then what is
That's
to be
all
done?
for commerce section because they had the commercial geography. No specific geography teachers we had in our student life.
No,
That's back then.
different.
Different. Now, your lordship, all that I'm trying to say, your lordships, qualifications of the teachers should not be restricted. The more they will teach themselves, the more
That is
they
different.
So
That is
therefore, it
different.
should not be restricted to anyone. If you have the experience, if law permits it to be considered, that should be considered. Law is not challenged like this. They say rewrite, republish.
Well, in this matter, maybe the prayer is not happily drafted, but there are matters where a specific challenge to the rule is there.
That's on the teaching experience.
Teaching experience.
That's yes, and then your loss is
No, first the court has to decide whether this prior teaching experience marks can be given or not.
That's-
Thereafter, whether 11-12 and that.
That's another aspect, your loss. But I'm confining my submissions to the present writ petition that this should not be permitted like this.
All right.
These are my humble sir.
My lord, with leave of my senior, my lord, I made a wrong submission. In this matter, we have not filed it in opposition. I stand corrected, my lord.
Not surprised. And one, man, sorry, give me 1 second. Mr. Samim is here. Mr. Samim's juniors. Primary, upper primary, out of context this was submitted. I tell you, lordships, the rule says only primary teaching experience to be taken, not the upper primary. So this was not cited, just running submissions. So your lordships, my submission, this should not be considered, taken into consideration. If that, then I have to give a reply to that. There's a rule permits. Rules only says only primary teaching experience up to class 4 and upper primary not. That's why primary board didn't take into consideration. Here is not the situation. Here is secondary level. These are my humble submissions. I'm taking a loss.
Yes, certainly. Yes, anybody else
In
who
this
would like to
matter
make
only
submission?
Can two, my lord, they have filed
Your
opposition.
prayer, how have you drafted your prayer?
My lord, I have not challenged the rule because, my lord, I have
You want the court to...
one thing is, my lord, I have stated and my lord, they make my submission, they have not following their rule itself, because there is this separately, they have stated there is the two, another, my lord, the experience separately. That's why, my lord, they have not entitled to marks teaching experience for 9, 10 to 11, 12. I am not challenged to set aside the rule, that is not, my lord. My subject to your lordship correction.
No, but then what your submission is and what you've made out in the writ petition are completely different. You say that what they have, their rules are proper.
Yes, because
You say that their rules are
categorically
proper.
stated, yes.
Then they have acted in accordance with the rules.
No, they has not getting, there is no, there nowhere stated, my lord, the both marks will be given to the 9, 10 to 11, 12 and 11, 12 experience to 9, 10. Because they have
Stated the rule says even in the 11, 12 level, secondary level qualification.
secondary also, my lord, subject to lordship, primary, upper primary also the secondary level.
Then you challenge it. You do not challenge. You say you accept.
He did not challenge. The reason is out of 15 petitioners, 1, 2, 3, 4, 5, 6 of them, they are already qualified in
No,
nine.
Before challenge.
I can give the numbers. That's the reason.
No.
He is the beneficiary of the recruitment process, and out of 15, 6 of them, they are there in the list.
The
That's it.
petition was filed when the results were not published. So he didn't know whether he'll be successful.
In
or
any
not.
case, there are 6 of them are there.
That's different.
No, I'm saying there are 6 persons. They are already in the list. They took the benefit of it.
Very well.
Yes,
After
that's what I'm saying.
publishing the result, I have not filed the writ petition.
No.
Yes, this I understand, but your prayer and what your submission is are not telling.
I have stated in my submission, my lord, and in this petition, my lord, only one opposition has been filed.
So what?
Neither state, my lord, we have filed any opposition or school service commission, not.
First, you have to make out a case. The case that you are making out and the prayer that you are making, they do not match with each other.
Yes, but
What is to be done?
I have, my lord, the subject to lordship correction. I have, my lord, specific my grounds, my lord, the 9, 10 teachers, my lord, they are not eligible for getting the teaching experience mark for, my lord, the 11.
The rule says they are entitled to. You have not challenged the rule. Then
I have challenged, my lord, the only conduct of the school service commission. They are not following.
How they are not following, I cannot follow.
My lord, kindly see page 57, 74, my lord.
Yes, 74.
There is the schedule 2, A and B is written separately.
So what?
So there is no, if, my lord, my submission is that, my lord, if the marks of teaching experience is eligible to all teachers, there is no segregation for 9, 10, 11, 12. There is the only one clause. Because they are categorically, my lord, stated in the different 2 clauses.
Please come. The petitioners in the instant writ petition participated in the second SLST, 2025. In respect of classes 11 and 12, only 11, 12. Stop. They allege that the commission ought to act strictly in accordance with the West Bengal School Service Commission, bracket open, selection for appointment to the posts of assistant teachers for upper primary level of classes, bracket, third bracket, except work education and physical education, bracket close, comma, classes 9 and 10 and classes 11 and 12, bracket close, rules 2025, page 64, rule এর নামটা দেখে নিতে পারবেন. Stop. According to the petitioners, comma, the commission ought not to award marks on account of prior teaching experience to the candidates who do not, candidates who taught in the 9-10 level. না কি দিয়ে শুরু করলাম? And do not have experience in teaching in the 11-12 level if they are participating for recruitment at the 11-12 level stage. Stop. The petitioners contend that only teachers dedicatedly appointed in classes 11 and 12 may be considered for providing marks on account of prior teaching experience at the 11-12 stage. Stop. Without actually taking classes in the 11-12 level stage, marks on account of prior teaching experience ought not to be awarded to them. Stop paragraph. The petitioners submit that the recruitment rules specifically lays down different criteria for appointment at the level at classes 9 and 10 and 11 and 12. Stop. The posts for classes 9 and 10 and 11 and 12 are different. Stop. The scale of pay in respect of the teachers for classes 9 and 10 and 11 and 12 are separate. Stop. Same experience cannot be counted twice for providing marks on account of prior teaching experience. Stop paragraph. The petitioners have prayed for issuance of a writ of mandamus, inter alia prayed for issuance of a writ of mandamus commanding/directing the respondent authorities and particularly the commission to publish notification by mentioning special benefits which should be given to candidates who intend to participate in the second SLST by considering their experience in their respective subjects and positions. Stop. The petitioners also pray for a direction upon the authorities to publish notification by granting full marks for lecture demonstration and publish fresh notification by giving clarity that lecture demonstration marks will be granted to the untainted teachers who have worked in connection with SLST 2016. Stop. Next. the several applications were filed in connection with the instant writ petition stuff. According to the applicants, the commission rightly published the rules by mentioning that prior teaching experience marks will be awarded to candidates both in respect of the 9, 10 and 11, 12 classes if the candidate has taught in the senior level, secondary level in a government or government aided or government sponsored school. Stop. The applicants who are opposing the prayer of the petitioners contend that the experience obtained by the candidates in the secondary level can certainly be taken into consideration for awarding marks on account of prior teaching experience for levels 11 and 12. Stop. According to the applicants, any classes above 9 and 10, above 9, has to be taken as secondary level classes, and the authority has rightly not made any distinction between the secondary, that is 9, 10 level, and higher secondary, that is 11, 12 level. Stop. Prayer has been made to dismiss the writ petition. Stop. Upon hearing the submission made on behalf of the petitioners and on perusal of the prayer as well as the documents annexed to the writ petition, it appears that though the petitioners do not challenge the recruitment rules directly, but indirectly the petitioners pray for a direction upon the commission to publish further notification by disclosing how marks are to be awarded to the participating candidates. Stop. Paragraph. The submission of the petitioners that the commission is not acting in terms of their own rules does not appear to have been own rules cannot be properly proved before the court. Stop. According to the recruitment rules, the rules, prior teaching experience in respect of classes 9 and 10 and 11 and 12 will be awarded to candidates provided they have the experience at the secondary level in a government or government aided or government sponsored school. Stop. The recruitment rules does not mention that for the candidates who are contesting for classes 11 and 12 will be provided marks on account of prior teaching experience only if they have got prior teaching experience at the 11 and 12 stage. Stop. The rules clearly specify that marks will be awarded to candidates both at the 9, 10 and 11, 12 stage if they have got experience at the secondary level. Stop. Next. This submission of the petitioner and the prayer made in the writ petition appear to be contrary to each other. Stop. The writ petition appears to be misconceived and cannot be allowed. Stop. The writ petition fails and is hereby dismissed. All connecting applications stands disposed of.
To judgment I have placed, my lord.
None of your judgments are applicable.
Liberty to file app.
No.
No, my lord, kindly.
No.
Deeply obliged.
After consuming such a lot of time, when it is brought to the notice of the court by the applicants who are opposing your prayer,
Kindly answer.
that your prayer is not proper, now you say you want to file afresh.
Kindly.
Sorry, sir. এখানে একটা লাইন একটু লিখে দেবেন তো, affidavit in reply filed on behalf of the petitioners against the affidavit in opposition filed by the applicant in Can 2 of 2025.
That was my opposition.
Be written with the records. 1 minute. This is item number 37.
31 টার cost writer বলো না।
Bishwajit Bishwas.
মানে may I India কি অপোজিশন দিচ্ছ নাকি? কপি দাও।
ঠিক আছে? অন্যগুলো বলছি।
দিয়েছি। কি চাইনি?
Yes, please.
হার্ড কপি দাও। হার্ড কপি দাও। But I not got the copy, my lord.
Which matter? All right.
But I not got the copy, my lord. It will be kind enough if
We-
I understand.
All copy will be circulated.
Yes.
We started off 1 minute. We started off from item 30 today,
Yes, yes.
right? Yes. Item 30, লিখুন একটু।
My submission was in 30 and also in 32 because
30
my
and-
opposition.
All
was
right,
30.
all separate orders are being passed possibly. Item 30 তে একটু লিখে নিন। Had submission made on behalf of the applicants. In Can, yours is Can?
Well, Lordship may kindly, my can was in 32.
30, you are not a party?
30 because Lordship was
Hearing all matters
hearing
together.
that's the reason I said Lordship may use that copies. It would be convenient. But my oppositions that Lordship has seen the earlier occasion, it was from 32 itself.
In 30, are you a party?
No, I'm not a party. 30, Dr. Gurushami mainly referred documents from 30. That is the
Right.
reason I thought that since Lordship might have marked in 30, I should not disturb it.
All right.
But I placed
You-
all my
You
documents.
were not there in
No,
30.
in 30 I'm.
All right, 30 তে তাহলে লিখো।
I am for the petition.
Well, one thing, but there is one thing. There is a can 3 in course they made, so kindly.
In 30?
Because effectively I made submissions, yes, in 30 also. Can 3.
Can 3 is there in the list.
Yes, so that needs to be allowed.
But before that,
That's by,
That is your Can.
yes, yes.
All right, তাহলে heard. Applicants in Can 3 of 2026.
They might have realized later that this.
Because all cans are of 25. This only I see in 26.
yes, and today's list, that is one can is.
Only one can is
Can
there.
there is no disposed of.
Yes.
Yes.
আচ্ছা তাহলে একটা অর্ডার লিখুন যে as any order passed in the instant writ petition may affect the applicant accordingly may have far reaching consequences Accordingly, the application being CAN 3/2026 stands allowed. Stop.
Deeply obliged.
Let the applicant, one or how many? You know nothing.
By this application card, Lordship.
Application.
There are three.
Achha, the applicants be formally added as parties in the instant writ petition. ঠিক আছে? It will be in Lubana. Did you file any opposition? It's already there.
Give a copy.
All right. And then who is going to make submission in Lubana? Item 30 now. Who's going to make?
It is my petition, madam.
Yes, but then the respondents are to make submission. Is it in 30? 32.
May I, because of that, madam, 10 marks challenge is there.
Mhm.
In another matter, my lord, another two, my lord, facet I could say, my lord. Because of that, my lord, one is that, my lord, in other subject, suppose a person who taught in
The one that I have dismissed today
That is
was
the rule.
not on merits.
No, my lord. That is rule is not challenged, but in my
Yes.
matter.
So this will not have any
So
effect
it will
on
be
the other
my matter.
matters.
So, my lord, it will be kind enough in this bunch, my lord, from item number 30 to 35, that is rule challenge. All matter are rule challenge. This matter is also, it has two facets. One is that, my lord, in other, suppose a person taught in English, got benefit in education subject, secondary education. So that is the challenge in this matter, my lord. Another thing is that, my lord, secondary. No. It is filed earlier.
Not in this bunch.
Not in this bunch, not in the year 20.
There are several matters
Several matters.
which are coming up.
My lord, that is filed earlier, my lord, not in the list, my lord. It will be kind enough tagged with this matter, my lord. Otherwise, my lord, these two facets is, one is that he taught in the English subject, he got benefit in the education subject, which is not permissible, and rule is challenged in this matter, my lord. It will be kind enough, my lord, take up this matter, my lord.
All right, you give the number,
Yes,
it
yes.
will be added in this list. No. Today I have spent the entire second
Second
session on this. Then how can it be taken up tomorrow?
My lord, then
I'll
item number 36, very near.
1 minute, 1 minute, I'll come.
Yes.
30, when do I keep it? The AG was here.
But there is now not that much of urgency because
Time
now
has.
time has been. That's
Yes.
what I'm saying.
The next week. Some matters were fixed next
On
week.
13th.
Also, my lord, your lordship has fixed that,
No,
after third
8th
council-
is just. So let
Okay.
us all have some
Yeah,
time.
yes, some breathing time should
On
be given.
Lordship may
Because
keep,
every day new points are coming up.
yes, Lordship may keep it all the matters on 13th.
So 13
Or
is
any, any other subsequent.
Matter that is expiry panel matter is already fixed.
Then I'll not fix it on 13th. Rule will be the later on. 20th of January.
Yes.
List 20th of January. 31, give. Yes, Shishir Dash. Affidavit in opposition, item 31. By the commission, filed in court today, is taken on record. Stop, let copy of the same be circulated. Released,
My lord, in third,
ওই একই দিনে, 20 তারিখে।
in,
20th.
in 32, I already filed my opposition and this was taken on record
Earlier,
earlier.
yes. So only one line order, list on 30th.
Yes.
30th, na 20th. All right. I was calling for advocates to make submission. At least let your juniors come prepared to this little bit of extent so that the court can proceed and the senior can come and take up. So they also get a chance to learn and you also get a chance to move around in different courts.
Yes, that I was expecting that.
Why are you
He is more worried about.
skip track? Acha, 33 list on 20th of January. Nothing filed in 33 today?
Not today, it was already filed.
34, 34, Choitali Mukherjee. Anybody filing anything in item 34? No.
The petitioner, my lord,
Tale list on ওই তারিখে. And 35?
nothing, nothing.
Nothing. All right, then.
For the petitioner.
Are you over with your oppositions in these matters?
Yes, yes.
In 35 minutes, we'll have to file.
There.
The,
36, in 36.
6 years.
my lord, 36, my lord, I will make, because of that, my lord's first order, 19 September order, 19 November, pardon me, 19 November order, Supreme Court specifically stated about this matter, my lord. My lord passed the order on 19th November, my lord. But till date, they have not published that list, my lord. Why, my lord? I just. My lord,
But then
para
one
30
of the orders have been kept, directed to be kept in
that
abeyance.
that is another matter. That is Subishwakar, my lord. That is not. But here, this matter, my lord, my lord, kindly take up this matter. I will not.
I'll take it up tomorrow or
So, my lord, kindly
any.
keep it tomorrow because of that, my lord. 19 November order not yet carried out. My lord.
All right.
Mousumi Mondol. Mousumi Mondol. Para 35.
No, no.
No, my lord. Mousumi Mondol is not a
35.
challenge.
Till 35, it is on the 20th. Moushumi Mondol is 36. This
Different matter. This is different matter. There is.
remain in the list.
Yes, ma'am.
As it
Because
is.
of that, my lord, there are several facets, my lord.
Right.
I will place.
আজকে যে স্লিপটা দিল ওটাকে রুল চ্যালেঞ্জ এই 35 এর যে বান্ডেলটা রয়েছে 30 থেকে 35 ওর সাথে দিয়ে দেবেন
Yes.
উইথ করে দিয়ে দেবেন
Because of.
all right 36 onwards tomorrow you give your appearance yes yes I'll hear everybody nobody will be shut out from here because that will be a good ground to challenge
36 is mine.
Lordship, before your lordship rises, my lord, the 415 fixed matter.
yes
My lord,
এখন তো 415 fixed matter the state and everybody who are there. So
My lord-
if the requirement of the police is required, I do not know, then they may be there.
No, my lord, I will tell your lordship about the present situation. No police help, nothing is required. Only,
is
my
the
lord,
money?
only, my lord, the execution case going on because he has instituted so many cases against the judicial officers. The learned JM is not executing the arrear amount. That is all. And my lord, I have prayed for attachment of his salary account. I have shown your lordship that order that he is intentionally not giving this order and telling that he is not getting the money, but it is there.
Come tomorrow.
That
let's-
petition is not being disposed of by the learned JM. my lord.
All right.
Grateful.